Let's get peppy. Welcome to PEP 268. That's Planet Extra Podcast. I am Chaz Lichadello, host of Planet America on ABC Australia, and this is an official podcast of the ABC. So say hi to the Ombudsman for me. On PEP, we cover all the stuff that's too nerdy for TV. If you're listening, you can find us on YouTube and Facebook at Planet PEP, and you can find highlights there as well. You also find timestamps and show notes in our blurbs, and if you leave a comment under our current episode video, we're likely to see it. Do not forget to subscribe for all that peppy goodness. It all helps. Actually, great call to subscribe now, so you know when we come back in a month or whatever. You won't miss anything if you subscribe now. Do it. You can also tweet us or blue sky us at PEPCHASDRDAVE. That's at PepChaz Dr. Dave. If you want to chat to some fellow peppers, you can join our Discord server. It's on the screen now or in the blurb of the podcast, and I will be there during my holidays because I can't be helped. But if you want to contact me or Lockie the Lucky privately, why not email us? The address is producer@pepthepodcast.com. Again, the address again is producer@pepthepodcast.com. We are recording this at 9 a.m. on Tuesday, 7th of July. Sorry, 9:30 a.m. now, or 7:30 p.m. on Monday night, East Coast time. That's a weird time for us. But we are joined by the lady who simply will not raise the stakes in controversial views, especially when we're talking about Supreme Court decisions, Melina Wicks. Hello, Melina.
Hello. How are you?
I'm great. It's great to see you in the studio. This is the first time for a long time.
Yeah.
She is back indeed. Now, this is a Supreme Court special, yes? Mm-hmm. I don't know how long it took you to go through those cases, but it took me a long time. So much for the holidays so far. I've been going at about 3 to 4 hours per case. There's 9 cases we're covering today. That's a lot of hours. What are you grateful for, Melina?
You know, I can't really think of anything. Just kidding. I'm grateful for the Knicks. Oh, my God. Okay. Apologies, everyone, for this indulgence, because even for people who care about basketball, this is old news, and I know a lot of people don't care about basketball, but the Knicks won the championship for the first time in 53 years.
So
I am still so excited about it. I am conscious the last time that I was on PEP, I said they had no chance of winning. Yes. So I'm going to explain myself. That was for 2 reasons. The first was they had a bit of a weird regular season. We don't have to go into all the details. A bit uneven. But more importantly, as a Knicks fan, I am conditioned to expect the worst. And that suits my personality as well. I like to expect the worst in life and be pleasantly surprised when the best happens. I thought we had a shot last year before having my heart ripped in two by the Indiana Pacers. Yes. And I felt personally responsible because I got my hopes up. So this time I was like, I'm not making that mistake again.
So you're saying they won because of you?
Maybe I helped a little bit at the margins. I'm going to say it was mostly Jalen Brunson, but, you know, a little bit. Looked like we were heading that way again. We lost 2 of the first 3 games in the playoffs. It was not looking good. And then in the middle of a playoff series, it was totally changed the offense. And after that, we won 100% of the games not attended by Donald Trump. Incredible run. I've just never seen a team just like flip the switch from good to dominant like that. And just to give an indication of how dominant, we swept 2 teams in a row. The average margin of victory of the playoffs was an NBA record, 14.9 points per game. And in Game 4, after being down 29 points, they completed the biggest comeback in NBA Finals history, which was... Everyone after the game was like, did you watch the game? Did you enjoy it? I didn't enjoy it at all, actually, until the very end. I was very stressed. I was on the verge of tears for most of that game. I was like, oh no, we're losing. The tide is turning.
What game was that in the series?
It was Game 4. So we won.
It's Game 4.
We won Game 1 and 2 on the road. And I was like, we've got it. I actually felt good going in. I thought we were going to win going in. I just... Once we turned it around in the first round, I was like, I can see the path of how we're going to do this. And I think that it's going to happen. Didn't want to actually say it out loud, but I kind of had that feeling. And then we won the first 2 games on the road in the finals, which was incredible. And then we lost the Trump game, which was Game 3 at home.
Doesn't count.
Doesn't count. But then we went down 29 in Game 4 at home, and I was like, oh no. Like the Spurs, who were our opponent, young team, I thought, you know, that's why I thought we had the edge. So, very talented team, going to be incredible. But I was like, we have the experience edge. Like we are the team that's just gotten a bit better year after year after year. And I think that that's going to be the difference in this series. And, you know, obviously running hot as well. But yeah, I was just like, oh no, Trump came to the game. And then now everything is weird and the Spurs have figured something out and now it's all going to just I was wrong to get my hopes up again. Down 29 points, but they just chipped away. As soon as it was down 15 going into the fourth, usually teams like that, in a situation like that, then it blows out again. But I was like, this team has had so many amazing comebacks already. It's going to happen. And then it was just like edge of my seat. Like, is it going to happen? It is. It's going to happen. I was just like so excited. And after that, I was like, it's over. We've won the series. Game 5, which was the clincher, very conveniently on my very last day of maternity leave. I wasn't even stressed. I was just like, and it's on the road. I was like, it's almost anticlimactic because I know it's done. But anyway, it was incredible. It also just worth saying, they were a really likable team. Even people who are not Knicks fans were like contacting me saying how much they liked the team. They just played a really enjoyable style of basketball. It was really flowing, like team involved. Players were unselfish. Many were underrated players, all playing for each other. Lots of ball movement. It just looked fantastic. It was really enjoyable to watch. I am so grateful for the team. It was an incredible run to watch. I have watched so many years of terrible basketball that to see this team just build year by year and become this juggernaut was the purest joy. And to bring it back to politics for a minute.
Do we leave politics? When we talk about politics in this podcast so far?
I feel like, and interestingly, Wolf has started to touch a little bit on this thought as well the other day, but I feel like politics has been treated more and more like sports over the years, and it's made politics worse. I don't like this trend in politics, especially because we have sports for sports. We don't need politics to be sports. We have sports for that. Sports is the healthy outlet for the feelings of tribal partisanship, being like, I love my team no matter what, no matter how bad things get. I'm backing this team. And no matter what's going on the other team, I hate that team. I hate everyone who plays on that team unless they come to my team. I hate them for no reason. I hate everything about them. They're the worst. Like that tribal partisanship where you just mindlessly go for one thing and be against another thing. Sports is the healthy outlet for that because it can make us feel so good and so bad and feel like so attached to things that are beyond our control. But the consequences are not important at the end of the day. Like, it doesn't matter. Obviously, it matters deeply to people who are fans on that personal level, but like, you can kind of just enjoy it in that way because it doesn't have grander consequences for the rest of the world. So shout out to sports for that reason. I'd
go further. I mean, number one, I think what you're saying is true, but also I'd say in sports, we do tribal stuff right.
Yeah.
In a way that we don't do it with politics. And I'll give you an example of what I'm talking about. I haven't been following the NBA. I was an NBA person like 30 years ago. I haven't been for a while. So I don't know much about the Knicks, but as a sports fan as well, like I couldn't help but glow when I was watching you celebrate your team winning a premiership, winning a ring the first time in 53 years. Because every sports person, every sporty person appreciates that. Like we all appreciate that. Even people from the San Antonio Spurs would have been happy on behalf of the New York Knicks, even though they were devastated for their own team. Every single person. And I've been on the other side of this when Melbourne beat the Dogs in 2021. I was obviously devastated as a Dog supporter, but at the same time, you're just happy for Melbourne supporters because they had waited 46 years or whatever it was. Like every single sports person appreciates the feeling of your team hasn't won for generations.
Yeah.
And they won. Everyone appreciates that and everyone can get behind that. But in politics we don't.
True.
There were no Republicans celebrating the Democrats winning 992. I can assure you of that. There's no happiness for your team finally got to go. That's not how it works in politics. It's just you just want more and you just want more and you just want more and everyone's awful and niggardly and horrible.
Yeah.
But in sports we're not. And in sports we do appreciate each other's cult heroes. We can see across tribal lines in a way that people can't in politics.
Yeah, like I can appreciate the excellence of the players on the Spurs, and like it's exciting for Spurs fans too. They've got their team, their very young team, and incredible players, and it's just like I'm happy for them in the future. I'm glad this is our year. But you know, it is a thing where you can enjoy watching it play out as well, even when you have a rooting interest. So yeah, I am very grateful. I'm still so happy about it. Also, while I'm running hot, I'm also a Sydney Kings fan, and the Kings won the NBL this year, and I saw Game 3 of the finals in person, and it was awesome. So it is a dream year of basketball for me. So I am grateful for all of that.
That's fantastic. Honestly, yeah, sport's awesome. It's so silly and it's so awesome.
Yep.
And, look, it's really easy for me, the grateful. I'm grateful for a holiday. I was going to do a correspondence after this, but you know what? I've already chewed up a week of my holiday reading Supreme Court cases. I'm done. when we're going to come back quite early on PEP compared to playing America, we'll have a bit of a run up and I'll do a few correspondences because honestly, you guys reacted so well to Justin Woofers. I hope he saw those reactions. Definitely try and get him back. Some awesome correspondence on AI stuff, and I definitely want to go through it, but just not before my holiday. I started sleeping for a couple of days, and then I stopped sleeping because of Supreme Court stuff. Man, that sleep felt good. It's just awesome. I missed Easter this year. I needed a break so bad. I'm not even reading it at the moment. Like Jared has been sending me texts about stuff that's been happening. I'm like, no, have no idea. I gave up reading the last Wednesday. So it's just apart from Supreme Court stuff. And it's wonderful. So yeah, I'm not retiring, but I am going to enjoy the little break. No doubt about that. Now let's stop messing around, Melina, because we have 9 cases to get through. That's not every Supreme Court case, by the way, in the last few weeks, but just the 9 biggies, basically the 9 last ones. By my calculations, that's 20 plus change on each one. Some will have more, some will have less, but means we've got to roll through. So let's get into it. I'll start with the first one, which is the oldest one from the ones we're going to go through, which is the Hawaii guns case. I'll give you some background to begin with, just about the whole guns scenario. First, I need to take you through the Bruin case. Back in 2022, that was arguably Clarence Thomas's greatest ever monstrosity. He can be fun, Clarence Thomas, when he's writing some way out one person dissent that no one joins. You go, oh, wow, that was an interesting little departure there from reality. But when he's actually rewriting gun laws for the entire country, that's not good. And the Bruin case struck down a New York state law that barred most people from carrying guns in public. It was how it struck down the law that was the problem. Bruin established a 2-step test for upholding gun laws. 1, does the Second Amendment's plain text cover an individual's conduct? If so, the Constitution presumptively protects that conduct. And then you go to step 2. If the law is presumptively covered by the Second Amendment, the government must then, there's a quote, the government must then justify its regulation by demonstrating that it's consistent with the nation's historical tradition of firearm regulation. Only then may a court conclude the individual's conduct falls outside the Second Amendment's unqualified command. So, is the challenge gun law relevantly similar to a law that existed when the Constitution was written? That's the test. Now, later on, there was another case called Rahimi that tweaked that test a little bit. Rahimi involved a law banning domestic violence assailants from having a gun. Obviously, a law that no conservative wanted to defend. But they didn't have domestic violence laws back in the 1700s, did they? So how are you going to find a relevantly similar law? They fine-tuned the test to say the government need only identify a historical analogue. They don't need a perfect match or a dead ringer. Okay, so now let's go to Hawaii. Their new law, basically set a default of no guns being carried on private property that's open to the public. So we're talking about stores, basically, unless there's a sign saying they can carry guns on the property or the gun owner gets explicit permission from the property owner beforehand. Now, obviously, most people aren't going to be entering a property unarmed finding the manager, asking them permission to carry their weapon onto the property, go home, come back with a gun. Unlikely, right? So this law effectively bars guns from nearly all bars. Bans guns from nearly all bars, restaurants, shops, gas stations, other places of business. Doesn't really matter. The Second Amendment types call it the vampire rule because you have to invite vampires in before they can enter your house, right? Now, this turned into a Supreme Court case, Walford versus Lopez, which is the Hawaii guns case I refer to. In this case, Hawaii argued that their law didn't infringe the Second Amendment because it wasn't about guns. It was about property rights, they said. No one has the right to enter your private property without the owner's consent, guns or not, they said. Simple. Not about guns, it's about private property. You can have the right to carry a gun, just not in my shop if I don't want you to. That's the theory. Okay, that's number one. Secondly, they argued that Hawaii has its own history and tradition of strict gun regulation. And thirdly, they cited a bunch of old American laws, which you need to do under the Bruin test, that they said were quite similar to the new gun law. There was a 1721 Pennsylvania law, a 1722 New Jersey law, a 1728 Maryland law, a 1763 New York law, and a 1771 New Jersey law. To take the Pennsylvania law as an example, they're all pretty similar. The Pennsylvania law made it illegal to carry any gun or hunt on the improved or enclosed lands of any plantation other than his own without securing license or permission from the owner of such lands or plantation. That sounds pretty similar, doesn't it? Right. Obviously, 1700s-y, but the same vibe. Hawaii also said that the law was similar to an 1865 Louisiana statute that banned, quote, carrying firearms on the premises or plantations of any citizen without the consent of the owner or proprietor other than in lawful discharge of a civil or military order. Once again, sounds pretty similar. Do you have any thoughts so far from what I've described? Does this sound like you think it's going to be legal or not legal, or do you have any thoughts at all so far?
I'm not guessing the result. I know the result, but I do think it's clearly an end run around gun rights because, and I can it doesn't surprise me that it was sort of not found in favor of with the court because it's you're as you say, you're basically making it impractical to exercise the right that you have to carry a gun around when you're around about town. Because if it's sort of presumptively banned everywhere you go, then and this was the government's argument, the Trump administration's argument, like you're effectively putting people at risk of breaking the law anytime they enter, a shop or something. So it's not that I love the idea of people carrying guns around everywhere, but it doesn't surprise me that it was sort of looked at with skepticism because it's clearly the intent is to do an end run around rights that are kind of pretty established. I
agree. Now, Alito wrote the majority, and the result was 6-3 along partisan lines. The first question we have to deal with is the law presumptively unconstitutional? Alito said yes. He wrote, no party disputes that petitioners are amongst the people protected by the Second Amendment or that they seek to bear arms. Therefore, the plain text of the Second Amendment protects what petitioners want to do, carry handguns for self-defense. Now, the dissent, Sotomayor and Jackson, Kagan did not take part in this part of the dissent, even though she was dissenting. The dissent disagreed. They argued that Hawaii's law does not restrict the right to carry a gun at all. Instead, its law vindicates its residents' property rights by operating on the scope of the implied license to enter. Once again, about property rights. Now, I think Amy Coney Barrett just hit this out of the park. She wrote a concurrence that, she dealt with the property rights argument, I think. I'll quote her. No one doubts that all property owners in Hawaii could bar the carrying of arms on their respective premises if they wanted to. But the Second Amendment does not apply to private parties. It does apply to the states. And when a state enacts a property law that regulates arm-bearing conduct, that law implicates the Second Amendment. So she's saying it's the law setting default. That's the problem. If the shops want to put up signs saying no guns, they're welcome to do that. But as soon as the government starts making laws saying this is the status quo, that's messing with the Second Amendment. And she drew an analogy to make this theory crystal clear, which is the bit which I love. What if a state made it a crime to wear religious headgarb, say a hijab, onto private property, open to the public, without obtaining express authorization? Could that statute evade constitutional scrutiny? On Hawaii, in the principal dissent's logic, the answer is apparently yes. No one has the right to enter another's property without permission, and the state has merely adjusted the default to require permission to be clear. But that is plainly wrong, because the law regulates religious and expressive conduct. Its enactment is state action that triggers First Amendment scrutiny. I think that's really hard to argue with. If you had a law saying it's illegal to wear a hijab unless someone gives you permission, you go, well, that's obviously a violation of the First Amendment. Do you agree?
I agree, yeah. And I also think, just from a practical perspective, it's sort of a weird law, because do you really want people to be in a position, if you're working at Starbucks and someone comes in and is like, can I bring my gun in here? Like, does anyone want to have that conversation?
Don't make that person mad.
Versus just putting a sign out front saying no guns here, which is still absolutely allowed to do under this precedent.
Yes.
You know, it's just like having a no shoes, no shirt, no service sign. Like, you can set your own rules. You're allowed to do that. But, you know, to kind of force people to have these conversations, I think is sort of a bit, you know, unrealistic in the times we're living in, where it's just a fact that Americans are allowed to carry guns everywhere.
I agree. What about, though, Hawaii's history and tradition? Now, Alito rejected that as relevant. He said, the Second Amendment has the same meaning in all parts of the United States. It cannot give way to the spirit of aloha in Hawaii any more than it can yield to the spirit of the Big Apple or the Windy City. Okay, third, the next part is, did the old analog laws that they could that they cited justify this law? Alito dismissed the 1700s laws because he said they principally targeted unauthorized hunting, and their coverage differed sharply from that of the Hawaii law now before us. The old laws applied to land where game could be found, not retail establishments that residents of cities and suburbs frequent as part of their daily routines. They had little, if any, impact on the Second Amendment's central objective, protecting the fundamental right to self-defense, and their obvious aim was to prevent the distinctive harms and risks associated with unauthorized hunting. So he said the gap between the state's anti-poaching analogues and its new rule is too wide. On the 1865 law, Alito said the statute Hawaii cites was part of Louisiana's Black Code. It provided a tool for disarming blacks and thus leaving them defenseless against attacks. And so once again, he said it was for a very different purpose from the Hawaiian law. So they're saying the what and how of these laws are similar, but the why is different. It's too different. Now, Amy Coney Barrett picked up on that. She said, even if Hawaii is right that the how is analogous, it also must identify an analogous why. The black codes were enacted to subordinate newly freed slaves. Hawaii obviously doesn't contend that its law promotes an analogous interest, so its law and the default rules in the black codes are not relevantly similar. Most would take that as a compliment. How do you feel about their interpretation of the analog rules?
I think it sort of is a reasonable interpretation in this case. I know that there are, potential contradictions in other cases, but yeah, I think it kind of makes sense. There are different reasons.
Well, let me tell you what the dissent had to say about this. I already told you about the dissent's focus on property rights. Let's forget that. Other than that, Jackson was very much focused on the fact that this new law was more than close enough to the old laws, in her view. She said it was garbage to say they were just about poaching. She quoted the 1763 New York law, which described itself as being enacted to avoid, quote, the great danger of the lives of His Majesty's subjects, the ruin and destruction of the most valuable improvements, the grievous injury of the proprietors, and the great discouragement of their industry. She also said while some of the laws were about hunting grounds, a significant number, quote, applied to the type of property at issue here, private property open to the public. The New Jersey law, for example, applied to, quote, any lands not the trespasser's own and for which the owner pays taxes or is in his lawful possession. that would necessarily have encompassed private property open to the public, including the type of locations to which Hawaii's law applies. Taverns, leathersmiths and blacksmiths, pharmacies, seed stores and merchants who bought and sold livestock. Eleanor Kagan jumped in at this point. She tapped in at this point in time. She wasn't so interested in their first argument, but this argument she took an interest in. Her entire dissent was one paragraph long. It was contemptuously dismissive. She compared the old laws to the new law. The how is identical. The new law, just like the old ones, sets a default rule against gun carry that a private landowner may reverse. The why is sufficiently close. Both sets of laws respond to the dangers and harms that someone with a gun can cause on another person's property. That the old laws had a special, though by no means exclusive concern with poaching does not matter. The key question is whether the challenge regulation is consistent with the principles that underpin our regulatory tradition. That's her quoting Rahimi. Here, the challenge law is consistent with those principles because it reflects, as the old laws did, the perceived abuses, damages and inconveniences that can be caused by persons carrying guns on other people's lands.
I think it kind of comes back to whether you agree that the Second Amendment in general gives this sort of unfettered right to guns, which is contested, between particularly Liberals and Conservatives. And if you think yes, then from there, all these other rights flow until it becomes inconvenient, like with Rahimi, with oh, okay, well, we don't want that. So let's just figure out a way to have a law that says no to that. But in this case, it's you can put a sign up if you don't want a gun in your property. So this law is fine. And, I think that for me, if you accept the fundamental premise that the Second Amendment is fine with everyone having an AR-15, then this kind of ruling makes sense in that context. But I also think it's probably worth acknowledging that fundamental question is still contested, very much.
I fully suspect if the left get a majority on the court, it'll be very much contested. For what it's worth, if I was a judge, I would have concurred with Kagan's dissent. I think the old laws are close enough, in my view. But I don't think the majority's view was horrendous at all.
Yeah.
I thought it was reasonable. I just probably would have ruled differently. I think that people who were making out like this was some horrendous decision, I think they're pushing it a bit hard. I think this was not unreasonable on its own merits. But what I do think was horrendous was the Bruin test in the first place. This whole test, in my view, is pathetic. And it's typical of the kind of ticky touchwood logical hall of mirrors that Clarence Thomas constructs when he comes up with some legal doctrine, and which they sound wonderful in a lecture, especially if you're talking to conservatives, but they just don't hold up to scrutiny of the real world. And that's what we're seeing here. His test essentially just allows judges to rule based on whether they like a law or not, essentially. And then they apply the so-called test in the most subjective possible way, which is what we're seeing here. Let's look at Rahimi again, the domestic violence case, one more time, just to make my point. In Rahimi, they said that laws banning gun possession for people with a civil domestic violence restraining order were close enough to founding-era laws that required individuals suspected of future misbehaviour to post a bond. And they would forfeit that bond if they later broke the peace. Those were the old-timey laws that they said were the historical analogues. Those laws didn't even involve guns. No guns. I'm just talking about misbehaviour, like assaulting people and stuff. No guns. Those laws had nothing to do with domestic violence. They had nothing to do with either element of the modern laws. And they said, yeah, that's close enough. For anyone to say those laws were close enough to strike down a gun law today, but the old laws that Hawaii pointed to weren't close enough, that's bullshit. The Hawaii laws were way closer than the Rahimi laws.
Because it's just a fact that people viewed domestic violence very differently back in those days. To pretend that, it's just on its face absurd that there would be an analogue.
But that's my point. This test is stupid.
Yeah.
It's a ridiculous test. So even though I actually think this judgment is totally fine on its own merits by itself, if you just take it out of context from anything else, it doesn't stand with Rahimi. One of those judgments is wrong, or both of them is wrong. because they cannot stand together. They do not mesh at all. And in my view, gun jurisprudence is now an arbitrary mess designed to provide unconvincing pretexts for striking down gun laws that conservatives don't like. And that's not how gun laws should be. So, so that's my take. Do you have anything else to say on this case before we move on?
No, I agree.
Okay. All right. Well, let's go to your first one, the trans case.
Okay, so in this one, the court upheld the right for states to ban trans athletes from sport in school. 27 states have passed laws banning transgender student athletes from competing on women's and girls' sports teams. This ruling explicitly didn't address whether states also have the right to affirmatively allow it.
Yes.
So, if California at the moment is still allowed to explicitly allow trans kids to play girls' sports, but there is another case coming down the pipeline that's going to look exactly at that. So they were kind of at pains to say, we're going to look at that separately. This is just whether you can ban it. Yeah. So we'll get a fuller picture of where the rights of trans kids to play sport are once we see that second case. The court agreed unanimously that banning trans people from girls' sport doesn't violate Title IX, which bans sex-based discrimination in education programs that receive federal funding, but explicitly allows for gender-segregated sports. So everyone on the court agreed it's not in violation of that. But there was a 6-3 ideological split on whether the laws were a violation under the Equal Protection Clause of the Constitution, which says the law cannot treat groups of people differently without a valid reason.
Okay.
So that's where we get the classic conservative liberal 6-3 splits. A lot of the arguments in this case were anchored around supposed scientific evidence. A key argument in this case was that the plaintiff had never been through puberty, so they made the argument on scientific grounds that the reasons for segregated sports, which is about safety and fairness, if you put boys and girls together, the argument is it's not fair from a competitive perspective. Girls can get injured. They're saying that doesn't apply in a case where someone has had puberty blockers, so therefore, those sex differences aren't relevant. And I think part of the problem with this case is ideally this would be a question that science decides, is that the case or not? Is it relevant or not? Rather than ideology and culture war stuff. But the science doesn't necessarily provide us with definitive answers at this time. And to that point, the court heard arguments about the scientific evidence on both sides of the case. So the transgender plaintiffs had evidence saying that transitioning before puberty prevents them from building enough body mass to have an advantage in high school and college sports. So saying if you don't go through puberty, there's no difference. Lawyers for the states that were trying to ban trans kids playing in girls' sports said that they had studies that showed that non-transgender boys and men perform better at all ages, and that their study found that boys between the ages of 7 and 12 ran about 4% faster and jumped about 7% farther than girls in the same age group. I don't know, the relative rigors of those scientific arguments, but from the court's perspective, they're looking at both sides saying the science is on our side, that this is okay or not okay. And I think that seemed to weigh a lot on the ruling, particularly Kavanaugh, who wrote the majority opinion. The court had looked at that and basically decided that state legislatures and schools were better placed to decide the rules around this issue than the courts. Kavanaugh asked why the court should constitutionalize a right for transgender women in sports when he says the science is still being debated. And he asked, why should we get involved at this point? So in a sense, it's kind of kicking the can down the road. And that could be a little bit of a clue as to how he at least might want to rule when we see the other side of that coin.
Wow. When you say he, this is signed on by all 6 conservatives.
Yes, although Clarence Thomas in his concurrence had a very different tone, shall we say, to Kavanaugh.
By the way, just before you go on, can I just say that, you mentioned the fact that the plaintiff in this case, BPJ, hadn't been through puberty. We know who BPJ is. That's Becky Pepper Jackson. She took puberty blockers at 10, cross-sex hormones at 12. And what that means 2 things. I think it's important to note early on. This means if we look at a photo of her, because we know who she is, she looks like a cis female. The terminology, she passes. That shouldn't be relevant. But that politically deprives social conservatives of the chance to demonize her. Right? It's not an accident, I think, that she was the plaintiff, right? The second thing it does is it shows there's no bleedingly obvious physical advantage that she enjoys over her potential opponents. Now, that doesn't mean that there's no advantage. Like if you see a photo of her with her mum, you can see that she's exactly the same size as your average female, right? So I'm not saying she doesn't have an advantage, like that's for the science. But what I am saying is not one of those cases where there's a trans woman who's twice the size of the women she's playing against. This was as ideal a candidate as you could possibly have for this particular case. And that's important because when we talk about the next trial, it's probably going to be the opposite. It's probably going to be the least ideal candidate to represent trans people in that case because they'll be selected by the opponents the next time around. Yeah. So anyways, but go on.
No, yeah, that's a good point. But yeah, to Kavanagh's point of, why should the courts be getting involved if the science, and when we say science, I am certainly not aware of any evidence that there's this huge swath of injuries occurring in these sports where, kids are allowed to play together and mixed gender sports is also a thing. So, you can say, but, when we're talking about those fine distinctions in science of is there, 4% advantage or, whatever the opponents are contending. I mean, you can equally argue why should state legislatures be getting involved in legislating if we don't know the answer or not as well. But, that's, I suppose, a different point. But, yeah, it does point to why they might want a more limited ruling in basically just saying a state government can set the rules around this if they want. That's effectively what they ruled in this case. Should they choose to rule the other way in the other case and say that blue states are not allowed to allow trans kids to play sport, then we can look back at this and say maybe it was an ideological ruling rather than one based on just staying out of it. So, we'll bookmark that for later. But it obviously is not a good result for trans kids living in red states where this is banned because, as we talked about earlier, sports is a great thing and denying people access to sports, I don't want to take that lightly. It is a real blow for the people in those states because, it's easy enough to kind of say, okay, the court's made it a state political issue, so lobby your politicians, try to get the law changed. But obviously, I well understand in a lot of these states, they're one-party states. The sort of anti-trans movement is very ingrained in Republican politics at the moment. And, I think that seeing any kind of change through the legislature at this time is a pretty long shot. So it is obviously a very bad ruling for people with an interest in these issues. I know you want to talk about whether they should have brought the case. Do you want to talk to that a bit first?
I've got a couple of sort of legal things first.
Do you
want me to talk about them now?
Yeah.
Okay. I think there's an important case that we have to introduce here, which is Bostock from 2020, which is the classic Neil Gorsuch case, which it was probably the reason this case was brought. This is back in 2020. The Bostock case involved the Supreme Court holding that you can't discriminate against transgender people in employment or housing because that's discrimination on the basis of sex. If a cisgender female employee can wear a dress, using a female, they can use a female name, they can present as female, then an employee who was identified as male at birth must also be allowed to do so, or you'll discriminate against them because they were born as a male, and that's discriminating against them because of sex. And as soon as that was held, that I think a lot of people went, "Wow." That means, I think it surprised people when that was handed down by a conservative Supreme Court. And they're like, wow, okay, well, let's go for it. And that, I think a lot of these cases were introduced because they were encouraged by that. And now they're discovering that, no, it didn't work out like that. First of all, in terms of legals, why not? Because BPJ brought up Bostock and said, well, hang on, aren't you discriminating against me on the basis of sex in exactly the same way as you said in Bostock? Let me first of all just read exactly what Kavanaugh highlighted from the Javits Amendment from 1972, which was an amendment for Title IX. It directed the then Department of Health, Education and Welfare to promptly issue regulations implementing the provisions of Title IX with respect to the prohibition of sex discrimination. The amendment further specified the regulations shall include, with respect to athletic activities, reasonable provisions considering the nature of particular sports. That quote became very important for Kavanaugh because BPJ said, well, reasonable provisions, look at me. I look just like a woman. Why? It's reasonable for me to be able to compete against women. Isn't it reasonable to allow exceptions for transgender women who've never gone through male puberty? And by the way, note that BPJ was not arguing on behalf of all transgender women, only on behalf of transgender women who hadn't gone through puberty, which was an interesting development because 2 or 3 years ago that wouldn't have happened. There's been a change in their position, the position of trans activists I'm talking about. And Kavanaugh went through all the usual arguments about trans women in sports you've heard before. I won't go through them. You've heard them a million times, from safety to fairness, all that kind of stuff. And then he concluded, separate sports teams for biological males and biological females are reasonable, given the inherent physical differences between the sexes. Allowing only biological females to play on women's and girls' teams can reduce the risk of physical injury and ensures fair competition. True. Some might prefer a different rule allowing biological males who identify as female to participate on women's and girls' sports teams, at least in certain circumstances. But it was surely reasonable for HEW in 1975 to draw a biological line, a line where biological males play only on male sports teams and only biological females play on female sports teams. Even in recent years, 27 states, the NCAA, the US OPC and the IOC have all drawn the same line. Now, I think from a legal point of view, that's hard to argue. You can agree or disagree with those blanket restrictions. I personally disagree with them. But it's hard to argue that they're inherently unreasonable when the IOC currently has exactly the same regulations. Like, that's a hard thing to argue in court. So that's before we even deal with any of the 7% jumping and all that kind of stuff. Whoever's science you believe, it doesn't matter for this. All that matters is, can you show that the regulations, if they have regulations, are not unreasonable?
Well, it is worth saying the IOC and the NCAA are not courts and not scientists. They do create their rules in the same cultural context that all of these other political debates are playing out. And
absolutely.
We shouldn't ignore that that's a factor in their decision-making when they're making their rules as well.
100%. I mean, like I said, I don't agree with these rules, but I just think for a court to rule they are legally unreasonable when there are professional leagues all over the world that currently have exactly the same rules, that's not going to fly. I guess the best way to put this is to say Bostock said you can't discriminate against sex at all for employment or housing. But when it came to women's sport, it was actually coded in that you're supposed to discriminate against sex because there's women teams and men's teams. That's part of the regulation. That was instituted when they started women's sport rules in the mid-70s. So taking this case was insane because trying to compare it to Bostock was just insane because Bostock was in a realm where you're not supposed to discriminate against sex. This is in a realm where you are supposed to discriminate against sex. And you go, okay, what other grounds are you using to say the rules are unreasonable other than that? And they had none. Like, this was never going to work, with one exception, which was the potential for the equal opportunity claim, which is then if you can prove the science thing unequivocally that you were right. And you have to prove it unequivocally that you were right because you're trying to force other people to not do something. Then you can win. But we're just not at that point yet. As you said, they've got competing scientific claims, inverted commas, scientific claims. So this was a tough case to take on at this point in time. Maybe in a couple of years' time when the science has advanced a bit more, it might be a bit easier. But right now, they were pushing shit uphill, in my view.
Yeah, I agree. And I think, we shouldn't ignore that when it comes to civil rights for any group, the people who are pro-advancing civil rights and the people who are trying to push back against civil rights for whatever reason, there is strategy that goes into this in terms of, you were talking before about the plaintiffs that they put forward, but it's also about the arguments that they push. And it's no coincidence. Like, there's a reason why in this debate we end up talking so much about sport and bathrooms and kids, because these are the kind of edge cases where people who don't have a strong view are more persuadable to either side, especially to the more conservative, I don't understand this, I'm concerned side of an argument, where, the most parts of society these days, we do not segregate by gender. And, employment, housing, we generally are not supposed to separate people by gender, and everyone's kind of considered equal, the same. It shouldn't be relevant. So it's not so surprising that, a conservative will sign on to the idea that you shouldn't discriminate against trans people in those contexts. But sport and bathrooms are two of the rare exceptions where most people feel that we should segregate by gender. Just not considering trans people for a moment, the majority, men, women, separate them. There is an argument for it. There's a good reason for it. So then when you turn to considering trans people in that context, suddenly definitions become important. And then we start getting into this area of, well, what's the science? What are, people can kind of argue those things more. And, my general attitude is just take an open-minded approach. If you can't point me to evidence that someone is being harmed by something, then you should allow it. That's my general position in all these kinds of things. But it's not surprising that these are the kind of topics where the people who are pushing against trans rights get traction, because it is a bit more confusing. It is a bit more ambiguous as to whether there is an argument for being discriminatory in this particular context. That's why we're talking about it all the time. It's the same with kids and puberty blockers and transition surgery, which I know is a thing that people say is happening when it's not happening. But it's, people get uncomfortable about the idea of things happening to kids that are potentially, serious interventions. And so suddenly people start having strong opinions that they wouldn't have when it's an adult, where it's like, oh, you're an adult, do what you want. So there, it's not a coincidence or an accident that we end up talking so much about these particular issues and why they become court cases and why this one probably shouldn't have become a court case.
Absolutely. And I'll just say, as evidence for what I'm talking about, 9-0. Sonia Sotomayor and Elena Kagan and Justice Jackson, they're Ketanji Brown Jackson, they're allies. 9-0. Yeah. It's a tough case. But the 6-3 part, even that is worth looking into, because if I read you the key part of Sonia Sotomayor's dissent, it's hardly a slam dunk. Let me read it. This majority holds that transgender girls like BPJ who wish to play girls' sports are not protected by the Constitution, even if BPJ is correct that neither of the state's interests is furthered by their exclusion. Yet the Equal Protection Clause demands much more when a state deploys a sex classification to achieve legislative aims. Perhaps West Virginia could meet those demands, perhaps not. In either event, because unresolved factual questions prevent the court from assessing the merits of BPJ's equal protection claim at this time, the court should allow the district court to address those factual questions in the first instance. Yet, in an opinion unencumbered by fact or law, the majority today cuts off that process prematurely, deciding instead that BPJ's case must end now. This litigation implicates deeply sensitive, contentious and evolving issues. These circumstances demand exercising judicial restraint, not rushing to answer conclusively difficult questions without sufficient evidentiary development. She's not saying they won the case. Like, her 3 in the 6-3 is just saying, hang on, don't end it now. We haven't got an answer yet. Send it back down to the district court for them to get more scientific evidence. That's her protest.
Yeah.
She's not saying they won at all. She's saying, well, maybe they'll win, maybe they won't. We just need more facts. That's all she's arguing at this point in time, which I think says a lot about where this is at in as far as the Supreme Court is going right now. There was a bit of a question about BPJ was saying, well, look at me as an individual. As me as an individual, don't worry about on average 4% jump. Just look at me. I have no advantage. I should be able to compete against cisgender women. Kavanaugh asked, how would courts draw those lines? Individuals come in all shapes and sizes with different height, weight, muscle mass, heart capacity, lung capacity, strength, speed, endurance, jumping ability, and so on. Particularly in the sports context, determining the effects of the puberty blockers and hormones taken by transgender athletes, and then comparing each of those transgender athletes' abilities to those of other individual biological males and individual biological females in the relevant sport would be an almost impossible task for a judge to perform on an equitable basis. The legislatures and the schools are better equipped, and under the Constitution are the more appropriate entities to assess the competing medical and scientific considerations and draw appropriate lines. Of course, no line that the states draw will satisfy everyone, but the judiciary is not the proper institution to make what would often be arbitrary and highly intrusive athlete-by-athlete assessments. Now, that's the quote that you described before. I wanted to read the exact quote. And the reason for that is because of what I'm about to say, my main takeaway, which is the big issue is the next case, not this case. This case was, in my view, never going to win. The next case is really where it's at. The next case being the opposite, being where social conservatives try to force blue states to not allow transgender women to compete against cisgender women. That's, as you say, probably coming next year. And there'll be a new context when, and like I said as well, the transgender girl who's going to be at the centre of that particular case is going to look nothing like BPJ. I don't know who that is yet. I promise you that the Conservatives are going to select the person who is the tallest and strongest and least likely person to pass under that next case. But there'll be a new context as well when that case comes. Because everyone is moving to the right on this issue right now. Everyone is moving to the right. Trans activists aren't arguing anymore that sports should be segregated by self-declared gender identity alone, which is what they were arguing 3 years ago. Now it's people like BPJ. They're the ones who are arguing, not just a person that comes out as transgender, 4 years later says I should be able to compete against women. It's not going to be like that from the trans activists. But the right is moving further right as well. We're now seeing the vilification of girls who don't seem sufficiently feminine. In Washington this year, they're literally voting on a ballot measure that would condition participation in girls' sports on a medical verification of sex, requiring either a genital examination or a blood test. They're voting on that, right? This is not a scare campaign. They're voting on that this year. A genital exam for school kids. There's going to be a state.
That's a great way to protect girls.
Exactly. There is going to be a state that's going to go for that. I'm not sure Washington will, but some state is going to go for that. That will be the context of the next trial, where the right have just gone way overboard and it's the left that are being, inverted commas, very, very reasonable and concessionary. That will be the new context. And when that next case comes, Kavanaugh just set a precedent. I just read it. And all 6 conservatives, even Clarence Thomas, signed on to it, even though Clarence Thomas, as you said, had a very, very inflammatory concurrence. I'm not expecting him to agree with this. Let me read you the quote one more time. The legislatures and the schools are better equipped and under the Constitution are the more appropriate entities to assess the competing medical and scientific considerations and draw appropriate lines. Of course, no line that the states draw will satisfy everyone, but the judiciary is not the proper institution to make what would often be arbitrary and highly intrusive athlete-by-athlete assessments. Now, I know some of the judges are massive hacks. They'll happily be hypocritical about this. Probably all of them will. But when that next case comes, the trans advocates should wrap that quote as tightly around Kavanaugh's neck as they possibly can. That is a massive gift, that quote, and that might be what saves transgender women being able to play sport against cisgender women anywhere in America. We'll see.
Yeah, and people noted, Kavanaugh talked, he, even before this case, was famously a girls' sports dad. He coached his girls' basketball team, and he sort of talked about that, and he talked in his ruling about, his relationship to girls and sports and the positive things it brings and everything. And I can easily imagine, I don't even think with a quote like that, it's like, oh, whoopsie, he said it accidentally and now he's going to be stuck with it. Because if you think about it from a reasonable person's perspective, think about it from his perspective, he may think, oh, well, I've spent a lot of time thinking about high school girls' sports and I wouldn't want my kid to play against someone who had an unfair advantage, whether putting aside whether that's the case or not. I'm pretty sure he also wouldn't want his daughters to be having to have intrusive tests to prove that they're girls.
Yeah.
So, when we're talking about something like that, I don't find it hard to imagine that he's not going to be wild about that escalation of events either.
Okay, I'm going to move on to Mullen versus Al Otro Lado, which is an asylum case. This was 6-3 along partisan lines. Let me give you the background. The Obama administration implemented a metering policy on the southern border in one particular location in February 2016, the San Isidro port of entry in California. At the time, there were a flood of Haitians coming through, and to stop the facilities being inundated, the Obama administration, ICE, asked the migrants to get a ticket from Mexican officials, like a butcher's shop, and they'd be called through in order. They didn't make them wait very long. It was pretty just basically just restoring order. In 2017, the Trump administration broadened that policy to the entire border, and then they also changed it. It stopped being, you have to wait a day or two. Well, look, some checkpoints, that continued as it was before. But broadly speaking, asylum seekers had to put themselves on a list. They'd be called one at a time. And in some checkpoints, people weren't called at all, ever. So that's kind of different. Some checkpoints by 2019 had people waiting for 6 months. That's a long time to just wait standing there.
Yeah, not to hear your case heard, have your case heard, but just to be in the system.
Yeah. We should say for the first 12 months of this policy, there was no reason for it at all other than cruelty, because border numbers dropped right off when Trump came in 2017. There was no emergency at all. Then 2018 numbers did build quite a lot, and what Trump was doing was becoming quite obvious by that point. But it was in 2017 that it drew the lawsuit without going, what's going on here? It wasn't so much the metering, but the total blocking of asylum that people objected to. And immigrations rights organisation Al Otro Lado and 13 asylum seekers sued the US government. They said the Immigration and Nationality Act required CBP to process asylum applications of people who reached the border, and that metering was not based on actual capacity problems. Then you had COVID. Obviously, asylum seeking stopped. In 2021, Biden rescinded the entire metering policy, making the lawsuit irrelevant, but it continued on anyway. The Ninth Circuit Court of Appeals panel in 2024 ruled the asylum seekers approaching an authorized border crossing are considered to be arriving in the US under federal law, and the law encompasses those who encounter officials at the border, whichever side of the border they're standing on. That's a quote. They emphasised, though, their ruling was not about the metering system, just about denying people any opportunity for asylum at all. That was the problem. They wrote, "We stress our decision leaves the government with wide latitude and flexibility to carry out its duties at the border. Even minimal steps by the government, such as implementing and following a waitlist system, would shift the analysis. But because the government in this case did not take any such steps, we need not and cannot reach the question whether any delay would have been reasonable." Okay, so now we get to the Supreme Court. The main argument was that the metering system broke the law because Congress legislated that all immigrants approaching a border checkpoint should be allowed to file for asylum. And the response by the government was, yeah, that's what the law says for people who are in the country, but not for people who are still in Mexico. The government argued, quote, "An alien on the Mexican side of the border may be close to the United States and may even have arrived at the United States border, but he has not arrived in the United States. And so the asylum application requirement does not apply to them until they've actually stepped foot in America. There's a lot of toing and froing about that language, which I will now go through. The majority was written by Alito. We start with the 1980 Refugee Act, which says that non-citizens were entitled to apply for asylum if they were physically present in the United States or at a land border or port of entry, irrespective of their status. That's very clear. At a land border, even if you're on the other side, you're still at a land border. Then they updated the law in 1996 with the Illegal Immigration Reform and Immigrant Responsibility Act. Section 1225A3 says all aliens who are applicants for admission or otherwise seeking admission shall be inspected by immigration officers. So the requirement remains, they have to let asylum seekers apply. Next, 1225B1 says an alien who is arriving in the United States and subject to expedited removal must be referred to an asylum officer if the alien indicates either an intention to apply for asylum under Section 1158 of this title or fear of persecution. So the key there is arriving in the United States. And finally, 1158A1 says any alien who is physically present in the United States or who arrives in the United States, once again, arrives in the United States. Now, Alito has a lot to say about this. Alito says, in ordinary speech, no one would say that a person arrives in a place, for example, a house, a city or a country, before the person enters that place. The context in which the phrase arrives in the United States is used in the immigration statuses at issue here supports an ordinary meaning reading. And he gives a bunch of examples. The running back does not arrive in the end zone, and 6 points do not go up on the scoreboard, when he is tackled at the 1 yard line by the defence. The guest does not arrive in the house when the homeowner locks the door right before the guest tries to open it. The army does not arrive in the city when the city's defenders repel the attack outside city limits, and the letter does not arrive in the mailbox when a dog assaults the carrier a step away from the mailbox. A person arrives in a destination only when he enters it, and that conclusion does not change because someone or something blocks entry. A person arrives in the United States then only when he enters it. Now, the dissent written by Sonia Sotomayor did not accept this at all. She said of Alito's examples, the majority is right that its chosen examples are naturally read to require the person or item to be physically inside the relevant space. The terms arriving in and arrives in, however, do not always work that way. For example, a train conductor's announcement, "We are arriving in Penn Station," might mean that the train is inside the station or merely that it has started slowing down half a mile away. If someone said, "Call me when you arrive in Washington, D.C., it would be logical to call them once you have landed at DCA Airport just across the river in Virginia. Nor would it be premature to say someone arrives in San Francisco while she is still driving on the Golden Gate Bridge. These examples show that the meanings of the phrases arrives in and arriving in depend on context. A more fitting example might be the following. Imagine a movie theatre policy that states anyone who arrives in the theatre may buy a ticket and all moviegoers must have their tickets scanned before entering. If a person walks up to a ticket booth located just outside the theatre, it would be unreasonable to think they could not buy a ticket under the policy because they're not in the theatre yet. Perhaps the policy could have been clearer by using the preposition at, but everyone understands from context what the policy means. What do you think so far?
I do think that Alito's linguistic examples are very clear and make a lot of sense, and that Sotomayor's are a bit more of a reach.
I 100% agree. I know what she was trying to, but her examples just aren't as good.
And they're not as good. Every one of his, I'm like, that's correct. Every one of hers, I'm like, there is a difference between arriving in and arrives in or arrived in, where it's like, if you're arriving in the station, it's like, yeah, that's arriving. You're in the process of getting there, but you're not there. Yeah. Every one of her examples, I was like, kind of, but not. If you're actually like trying to have a clear technical definition, then no, not really.
And with the train example, you're saying I'm arriving in Boston or whatever because everyone knows that train is in the process of getting there. It's going to get there.
Yes.
Like if there's a chance that you'll be stopped, then it doesn't apply quite so much.
Yeah. If the train stopped because there was an accident on the tracks and you had someone waiting for you at the station, you'd be like, I'm not there.
Yeah.
Because I'm stuck on this train.
Here at PEP, we know that there's a big difference between when Chaz is arriving in the studio and when he has arrived in the studio.
Excellent point, Lockie.
Lockie's first comment is on point. Absolutely true. Look, I agree entirely what you're saying, Melina. But Alito then gave a few more examples of immigration law using different prepositions to show that they are prepared at times to use arrives at instead of arrives in, for example, but they chose not to in this law. So that was his next piece of evidence, going they could have said arrives at. They do sometimes, but not in this case. But then Sotomayor said, yeah, they use arrives at and arrives in interchangeably. I'll read out that bit. For instance, 1231B1A, which governs the removal of arriving aliens, uses the terms interchangeably in the same sentence. It specifies that a non-citizen who arrives at the United States and is removed upon arrival shall be returned to the country in which a non-citizen boarded the vessel or aircraft on which the alien arrived in the United States. That provision refers to the same person in both instances, even though one reference uses at and the other uses in. And then she has a few more examples of the same thing happening. Going, well, look, they didn't care. Like, it was the vibe. Alito was unconvinced, and he noted that there is a presumption against extraterritoriality. He writes, this presumption is a long-standing principle of American law under which courts will not give a statute effect outside the territory of the United States unless Congress clearly expresses a contrary intent. And he argued what the dissent was providing was far from a clear expression of contrary intent. So the presumption holds they won't rule for the statute to have effect to people standing in Mexico. Have you changed your mind yet?
No.
Okay. I'm still with Alito. But the dissent had more. Sotomayor wrote that the majority's fixation on the word in had led it to ignore the legislative history and context that suggested that the INA was clearly intended to include non-citizens in the process of arriving. So some of that context. The 997 and 998 regulations drafted after the 1996 statutory update said the following. The term arriving alien means an applicant for admission coming or attempting to come into the United States at a port of entry. That's an interesting phrase. That regulation is still in effect today. Now, to be clear, that doesn't overrule the law. It's just a regulation. But it does give you some insight into the state of mind of how DHS is interpreting the law. Once again, an applicant for admission coming or attempting to come into the United States. Sotomayor also noted that the immigration laws have long afforded protection to those arriving at the border. But there is one more argument left, which I think was the plaintiff's best argument. Remember Section 1158A1, which said any alien who is physically present in the United States or who arrives in the United States may apply for asylum in accordance with the section, etc. Now, if arrives in means only those who are present in the country already, then all those people are already accounted for by the physically present description. And there is no point whatsoever to the phrase arrives in the United States. Because they said, once again, any alien who is physically present in the United States or who arrives in the United States. Why'd they say or if the two halves of the clauses mean the same thing?
Well, the first could conceivably apply to someone who, say, was in America on a visa and then the situation in their home country changes and they say, well, actually, I want to apply for asylum because there's a war where I came from and I don't want to go home even though my visa's expired, versus an example of someone who is fleeing persecution actively in that moment and arrives in the country.
But I mean, that explains the difference between, I mean, arrives in is a subset of physically present, sure. But you don't need to say arrives in if you said physically present. If arrives in means you have to be physically present.
Yeah, but they could, when I'm trying to think what could they have had in mind, they could have been trying to have language that in their mind covered different scenarios in which a person in the United States would apply for asylum. I don't know if that's the case. I'm just saying that's a potential
It's fair enough.
thing I could think.
That could be your response. That's fair enough. I'm going to ask you your verdict in a second. So you just store that one. There is also an assumption that Congress writes things for a reason and doesn't waste words. It's called the anti-surplusage canon. Not an iron law, but judges do use it when they're trying to assess Congress's intentions. Alito admitted this argument has some force, but does not overcome the arguments pointing the opposite way, is what he said. Okay, so how are you feeling now?
I tend to agree. I think it becomes there's a difference between the letter of the law and what is discretionary. So, it's very much the case that, under other administrations, you could have a more open policy where you say, sure, if you arrive at the border, and claim asylum, we're going to assess your claim. And then you can have the Trump administration come in and say, well, we don't want to do that. So as long as you don't make it in, we're not letting you in. We're not going to hear it. And so then it becomes a question of what does the letter of the law allow? Does it allow them to prevent someone coming in where there's clearly an obligation to hear the case? And looking at the letter of the law, I certainly see the argument. I think Alito's argument does make more sense by the letter of the law overall than Sotomayor's.
Fair enough. I gotta say, that last point brought me over to Sotomayor. But this is one of those ones where I think both sides are pretty reasonable. I don't think either side's a travesty. So I can understand we end up on different sides. The anti-surplusage canon stuff, that's good shit for me. But anyway, then there's the stuff which I don't think makes any difference. Alito said, in the end, this isn't a big deal because the rescinded metering policy issue doesn't stop anyone applying for asylum anyway. They just have to wait a few days. That's not true. It delayed them by 6 months and it could delay them forever. So that's either denial, wishful thinking, or gaslighting. Either way, it's bullshit. And Sotomayor picked them up on that and said some of those ports of entry were literally empty when they were turning people away. And finally, Sotomayor drew a comparison to the St. Louis ship that was transporting Jewish refugees fleeing the Holocaust that America turned away. Not really a legal argument, certainly captured people's attention. That's what all the newspapers wrote about. Look, I think that's a story worth reminding people of at the moment in general because of the immigration situation. But I'd say there are better Trump administration parallels to that story than this particular case, I would say.
Yeah, and there's a difference between whether it's a moral and good thing to accept more asylum seekers versus whether it's legally required in these circumstances. But yeah, I would say there's one thing I definitely did disagree with in Alito's ruling, which is sort of a part of what you touched on. But he made the argument that this ruling doesn't create a perverse outcome where people are now incentivized to try and take dangerous routes to get into America so that they can be in America and make their claim versus the orderly wait in Mexico for your turn. He's saying it doesn't matter because, as you were touching on, they can just put in their claim from Mexico. But those claims are not being processed. So that is one thing where I definitely agree with the dissent where they were saying that's ridiculous. There is definitely a perverse incentive created by this ruling that's going to encourage people to try and get in more dangerous ways. And I definitely agree with that. You can have legal rulings that create all kinds of perverse outcomes, and I think this definitely does that.
100% agree. This does encourage illegal immigration. Look, even though I was kind of ended up on Sotomayor's side, I do think both sides are kind of reasonable. Bottom line, this makes no difference. Let's just be honest. They stopped metering 5 years ago, and right now the illegal immigrants wish that metering was their biggest problem. Because the reason Trump doesn't use metering anymore is because he doesn't need to, because they've got much more hardcore ways of stopping asylum seeking. They've basically ended the entire asylum system unless you're a white South African. Yeah. There's much bigger problems than this right now. But the bottom line is, if Congress disagree with the majority's interpretation of the law, they can fix it tomorrow. This is a statute. It's up to Congress. Something tells me Congress, the Republican Congress won't fix this tomorrow, but they can. So don't blame the court. Blame Congress. This is down on Congress as far as I'm concerned. And blame the Trump administration for destroying Asylum. But anyway, so that's the first case. Second case is the TPS case, which I'll go into now. The Temporary Protection Status Program, legislated in 1990. Sorry, do you have anything else to say on that case? No. It provides temporary asylum for people from countries experiencing natural disasters or wars or catastrophes of some kind. It not only gives you legal status in America, but it also gives you work authorization for up to 18 months. After 18 months, the state of your country is reassessed and they might extend the TPS designation for another period. Also, your TPS is automatically terminated if you're convicted of 1 felony or 2 misdemeanors. Last year, TPS holders contributed about $29 billion to the economy and paid $7.8 billion in taxes. That's the program. The problem with the program, as far as people aren't such fans of immigration goes, if your country's screwed enough to qualify for TPS, probably ain't going to be much better in 18 months. And so it gets renewed and then rolled over again. Before you know it, they've had temporary protection for over a decade, at which point in time those people have planted roots in America. They want to go back to their old country, which probably still isn't very great, and it makes anti-immigrant types see this program as a backdoor for migration, essentially. Now, the Trump administration is trying to break that cycle. There were 1.3 million people from 17 countries in the TPS program when Trump took over. 14 of those 17 countries' designations have come up for review in the last 18 months. The Trump administration has removed the designations of 13 of those 14 countries that have come up for review. The one they didn't was Lebanon. They just gave a 6-month extension to Lebanon. Markwayne Mullin did, and you can see why. Lebanon's not a great place to be right now. The 3 other countries remaining in the program are El Salvador, Sudan and Ukraine. We'll see what happens to them when they come up for review. In the case of Haiti and Syria, which is the relevant one for this case, Haitians first received TPS status in 2010 after an earthquake killed more than 200,000 people. There was chaos afterwards, political unrest, gang violence. In 2021, there was an assassination of their president. They still don't have an actual legitimate government. Haiti's been in a national state of emergency since 2024, according to a US State Department advisory telling Americans don't go there. They couldn't even hold a World Cup game there because of the chaos. Syrians, they first qualified for the protections in 2012 during their civil war, which lasted until 2024, killed more than 650,000 people. There's a new government. Things are improving a little. The country's still basically in ruins. The impression I get is that the TPS designation for Syria, it's arguable. The TPS designation for Haiti, that's not arguable. That's really, really obvious. There are now 350,000 Haitian immigrants and 6,000 Syrian immigrants currently living in the United States under TPS status. So we turn to the arguments. The TPS statute says, this is section 1254AB5A, there is no judicial review of any determination of the Attorney General with respect to the designation or termination or extension of a designation of a foreign state under this subsection. No judicial review. That theoretically should be it, but it's not. The plaintiffs argue that all because you can't review the actual determination doesn't mean you can't review the process leading up to the determination. So in this case, the law specifically says DHS must follow certain procedural requirements. They have to consult with the State Department, they have to receive a review of country conditions, and they have to provide an explanation regarding his decision, according to statute. But in this case, Secretary Noem elected to terminate Haiti without receiving any information about country conditions from the Department of State, which is blatantly against the law. That's when this lawsuit began. So then a Noem staffer sent an email to a State Department staffer that read, we have the email. Due to the litigation, we are re-reviewing country conditions in Haiti. Can you advise on State's view on the matter? That's the whole email. And 53 minutes later, the State Department replied, State believes that there would be no foreign policy concerns with respect to a change in the TPS status of Haiti. Even if we pretended that was a good faith response, still not enough. The law requires consultation about whether conditions are safe in Haiti, not about foreign policy concerns. So we've seen the emails, they didn't comply with the law. The plaintiffs also argue that racism played a role in the determination. This is the constitutional case. Why does that matter? Because under the 14th Amendment, there's a constitutional right to equal protection if a government decision was motivated by race or, for that matter, national origin, then that right was violated. So for people going, Haitian isn't a race, national origin is also covered. The plaintiffs didn't have to go far to find that racism. These are all statements from Trump that Kagan cited. Haitians are eating the dogs, they're eating the cats, they're eating the pets of the people that live in Springfield, Ohio. Haitians are also eating other things too that they're not supposed to be. Also, Haitians in the United States probably have AIDS. Also, Haiti is a shithole country, which is filthy, dirty and disgusting. Also, Haitian immigration is like a death wish for our country. Also, Haitians, along with some others, are poisoning the blood of our country. Also, why is it we only take people from shithole countries like Haiti and Somalia? Why can't we have some people from Norway and Sweden? And if that wasn't enough, 3 days after Noam terminated TPS for Haitians and Syrians, she tweeted this: I'm recommending a full travel ban on every damn country that's been flooding our nation with killers, leechers, and entitlement junkies. Our forefathers built this nation on blood, sweat, and the unyielding love of freedom, not for foreign invaders to slaughter our heroes, suck dry our hard-earned tax dollars, or snatch the benefits owed to Americans. We don't want them, not one. It was the constitutional argument that the DC Appellate Court ruled 2-1 in favour of. They found race was a motivating factor. And they used as key evidence those statements I just read out.
Those super racist ones.
Yes. So, Melina, what are your thoughts so far?
Yeah, I mean, this is to an extent jumping ahead, but if the test for racism isn't passed with the most overt racism on the record, then there's no test. Like, that becomes a meaningless test from a legal perspective, and that is one of the outcomes of this ruling.
Do you have a view about the statutory question? The question about whether the no judicial review counts versus the process?
Like whether they did the process correctly?
Well, no, they obviously did the process correctly. But whether it matters whether they did the process correctly or no judicial review, can't go there.
I think the process should matter. That is my view.
Okay, all right. Let's see what the majority said. 6-3 ruling, decided along partisan lines, like so many things in these last few days. Okay, let's start with the process question. The question of the process behind the determinations. Alito said, the term determination can be used to describe either an individual decision or the whole process leading to a final decision, and under either understanding of the term, US Section 1254AB5A squarely bars all of respondents' non-constitutional claims. And he also said, if the final agency action is unreviewable, then so too are subsidiary determinations. This important principle ensures that challengers cannot avoid a judicial review bar by creative pleading or clever lawyering, he says. So he didn't buy that at all. We'll get to the dissent in a second. As for the constitutional question, none of the cited statements by either the president or the secretary was overtly racial, he said. And in substance, all express policy views that could rest on race-neutral justifications. For example, one may oppose TPS and favour tighter restrictions on immigration for economic or other reasons that have nothing to do with race.
One may.
Yes. One may. Alito pointed out that Trump has terminated almost every designation he could. From East Asia, from Central Asia, from the Middle East, from Africa, from South Sudan, from Central America, from South America, from the Caribbean. And yes, there are no white people there, but the evidence is pretty clear that Trump hates migrants from all over the world. Let's recall that Kirsty Noem quote. I'm recommending a full travel ban on every damn country that's been flooding our nation with killers, leechers, and entitlement junkies. Our forefathers built this nation on blood, sweat, and the unyielding love of freedom, not for foreign invaders to slaughter our heroes, suck dry our hard-earned tax dollars, or snatch the benefits owed to Americans. We don't want them, not one. Melina, doesn't this all just show anti-immigrant animus just as much as racial animus?
Except for the Norwegians and the white South Africans.
Yes.
Sure. Like, in all seriousness, if there was someone whose policy was, we actually have just like too big a population in this country and just no more immigrants from anywhere in the world for population control reasons as of today, Would I say that's racist? I mean, I'm not precluding that person could have racial motivations, but there is a possibility that you could have that position for non-racist reasons. But Trump could not be more obvious when he's saying, except for the Norwegians, when it's like, we don't want refugees, except white South Africans. He explicitly carves out the whitest people in any given situation he can think of to say they're okay. So the idea that, oh no, he just hates immigrants. Why does he hate immigrants? I can't imagine, except for his statement saying Haitians are poisoning the blood. That may give us a bit of a clue.
I 100% agree. And by the way, so does Kagan, who wrote the dissent. Kagan, on this point, Kagan wrote, the majority briefly replies that those remarks are not overtly racial. But it's hard to know what that means. Haitians are black. Norwegians and Swedes, not so much. The references of filth, disease, and primitiveness are shot through with racial stereotypes and tropes. And I completely agree. The Norway-Sweden thing, that's the smoking gun. Yeah. There's no denying that. Also, I agree about the white South Africans, which she didn't really get into. But I think that's a key point. For those who don't know what we're talking about, the Trump administration has literally zeroed out all refugee intake except for white South Africans, who, by the way, are pretty borderline as far as refugee claims go. Not only have they accepted only white South Africans, but they've more than doubled their projected refugee intake from 7,500 to 17,500, just so they could take in more white South Africans. And you might not have heard this. When they get here, you know what they're given?
No.
They're given a gift bag with an iPad. That's not sounding very anti-immigrant to me. So I would argue that Trump's, in quote, anti-immigrant mindset is in itself a sign of racism, not an alternative to racism, as Alito suggested.
Yeah. I think there can be like an overcorrection at times where sometimes people throw around racism too readily. And so then, you get this counter reaction that's like, just bending over backward to never call anything racist because we don't know for sure what's in someone's heart. Maybe they're not racist. We shouldn't say it too readily. But when someone says something super racist, we should be allowed to call it racist. And yeah, I would also flag as well, like a lot of people have foreshadowed that next year Ukrainians' temporary protected status is up for assessment. And get ready if he revokes the status of Ukrainians for a lot of people to be like, see, it was never racist because he revoked the status of the white people as well. Sorry, we know Trump hates Ukraine. That's not convincing me that there's a difference just because in this particular case, he also sees one group of white people as undesirable immigrants. And, just to draw the comparison, to not draw the comparison, I'm not saying Trump is Hitler. I'm not saying they're the same thing. But Hitler didn't like Slavs and thought they were lesser than white Germans too. So you can hate certain kinds of white people as a racist. It's not exonerating evidence. So I'm just going to put that on the record now so that if he down the line revokes the status of Ukrainians and everyone's like, yeah, see, he loves everyone. No, not buying that.
Even if you use the not racist in their heart talking point, Kagan's got that covered, which I'm going to get to in a second. Before I do, I want to make one other point, which is a point that Kagan didn't make, but I want to make it just quickly about the whole this isn't necessarily racism, could just as easily be anti-immigrant thing. There was a 2009 case on affirmative action, Ritchie versus DeStefano, where Alito wouldn't have a bar of pretext that excused alleged discrimination against white firefighters. And in 2012, Alito agreed. The Colorado Civil Rights Commission showed anti-religious bigotry when they used the word despicable to describe a Christian baker's refusal to sell wedding cakes to a same-sex couple. Despicable. That's it. Alito has a history of being extremely sensitive to potential bigotry against white people and especially against Christians. But he seems to have nothing but excuses when the bigotry is going the other way. So I'll make that point, even though Kagan didn't. But to your point about the racists in their heart excuse, Kagan, because she's a judge, goes very big on the legal doctrine called the Arlington Heights test, which I will now explain. The DC Appellate Court also used that. The Arlington Heights test says a government's decision is invalid under the 14th Amendment if racial discrimination or bias is a motivating factor. Not the most, a. I'll take it up. I'll then now quote Kagan. I have no doubt, as the majority says, the current administration is generally hostile towards immigration and prior TPS policies. I also have no doubt, again with the majority, that those views may be held for reasons having nothing to do with race. But under Arlington Heights, that's not the end of the matter. If in addition to race-neutral reasons, race entered into the picture even as a subsidiary factor, the Haiti TPS decision is irretrievably tainted. And here, the president's own statements show that race did enter in, that within what was surely a multi-cause decision, it was a motivating factor. It was a motivating factor. And that is all the Haiti plaintiffs need to show on their equal protection claim. So if it was motivating at all, in any way, it doesn't matter what's in his heart, like whether he mostly hates immigrants, just the Norway, Sweden, and the white South Africans alone is enough to show that. So she's got him covered. By the way, normally you combat those accusations by showing you would make exactly the same decision even without the racial issues. But they can't do that in this case because Haiti is obviously still a wreck. So it would qualify for a TPS status. So they can't use that. Now that's the equal protection thing. But we skip past the statutory thing. I'll just go back to that. Kagan argued that the TPS statute does allow judicial review of whether the secretary adhered to the procedures it mandates. She wrote, the TPS statute makes plain Congress insulated the secretary's designation determinations from review, that it did not want judges overriding secretarial decisions made with proper consultation about conditions in foreign countries. But the majority's holding makes everything in the statute precatory, that means optional, for those who don't speak judge. The majority's holding makes everything in the statute optional, including procedural requisites whose enforcement would seem to fall smack in the middle of judicial wheelhouse. After today, a secretary can announce to the world that she didn't consult with anyone, more that she didn't evaluate country conditions at all before making, extending, or terminating a TPS designation. And the courts will be powerless to intervene, even though Congress loaded up the TPS statute with the requirements about the altogether different way the Secretary is supposed to make her decision. And then she points out that unless Congress doesn't care if the law they wrote is actually followed, then the majority has gone wrong.
Yep.
And if that's not good enough, she's got precedent as well. Just last term, this court observed that the word determination is, quote, a term of everyday usage, and then said what it means. The settling and ending of a controversy, the resolving of a question by argument or reasoning, the decision arrived at or promulgated, or a determinate sentence, conclusion, or opinion. Missing from those definitions, or any other you as an English speaker would naturally come up with, is any suggestion that events preceding a determination, including required procedural steps, are properly referred to as the determination itself. And then she cited yet another case that construed the word determination in another judicial review bar as describing a single act rather than the procedure employed in making decisions. Now, Alito found those precedents unpersuasive for various technical reasons, which I'm not going to go into because they're very boring. I will say his reasons are not terrible. They're in the world of reasonable, but they're very technical. Whether you credit that or not, I think the constitutional arguments are pretty strong. What are your thoughts?
Yeah, I agree. I don't agree with this ruling. I would say, it's the policy itself, while it sort of makes sense in theory, does create problems as it exists, where you have a situation where you have these people who are, effectively, sometimes a country, has a war and then the war is over and everything is back to normal. But more often than not, once a country is in enough trouble to warrant this status in the first place, it's going to be problems for a long time. And you do have the situation where you have all these people that live in limbo for years or even decades, and then, they are vulnerable to changes in policy and, it's in the instance of the Haitians, like Mike Lawler, who is a Republican House member from New York, he was not in favor of this ruling. And he was talking about the problems it causes. And one of the points he made was he was saying of the 350,000 lawful Haitian TPS holders, roughly 1/3 work in our healthcare system. Immediately shutting off TPS will create a crisis in our hospitals and nursing homes. So you have the situation where people become embedded in their communities. They kind of are effectively just like permanent residents, but they don't actually have that protected status. And now the rug's been pulled out from them. So, I think that the practical outcomes of this ruling are really bad. I agree with the legal argument that, why would Congress bother to put in these rules if they had no expectation that anyone would follow them? And that also, clearly they've been racially discriminated against the Haitians in this case. But, in terms of the actual policy itself, it is also something where I'm like, there are definite problems with how this works in practice that in an ideal world, there might be better congressional resolutions for, but not just ending it and putting all of these people in this incredibly vulnerable situation.
Pick up where you left off first, which is the pragmatic considerations, the policy considerations, and I agree. It's policy-wise, this is horrible. Obviously, for migrants, Haiti is a hellhole. Some of those people are young adults who have no memory of Haiti. They don't belong there. Sending them back would be awful. It'll ruin their lives. Theoretically, they can apply for permanent status, but to do that, they need to apply from outside the country. That's the law. And for many TPS holders, there'd be an automatic bar to re-entry of 10 years. So their lives are going to be destroyed, whatever happens. So that's from the migrants' perspective, it's awful and not fair. From America's perspective, it's awful. America needs people. And it needs people who work. These people would have been rejected by now if they were criminals. TPS gets taken off you if you commit a felony. It only stays there if you're working and you're a productive member of society. So these people are exactly what America wants.
And I note that Stephen Miller's been out in the press referring to them as illegals. It's like they were not illegal until you tried to make them illegal. Like it's the same with, we'll get to birthright citizenship. But, these administration that's obsessed with illegal immigrants is trying to create a whole new classes of illegal immigrants. It's so it's not illegal immigration that you have a problem with. It's immigration. Different.
Absolutely. And as you say, they perform valuable roles in communities. Look. Let's just look. Okay, I'll give you an example. There's a clip which I think everyone's seen, but let's look at the long version of the clip, just because I think this really shows what we're dealing with here. If there's concern about whether there's racism involved in this decision or not, I know she didn't make the decision, but let's go to Megyn Kelly.
Go home. Get out. We know our country's better than yours. That's because we filled it with our work ethic and our culture and our values. You being here only dilutes it for us, those who built it and live it. And half of you people, more than half, you won't assimilate. We don't want you. We don't care if you're offended. Get out. Go home. Go back to fucking Haiti. Sorry. I'm thinking about our friends in Ohio who've been dealing with these TPS Haitians for years now, who are drunk driving all over their towns and killing people. This is the whole cats and dogs thing. Like they don't want to live like Americans live. And this was supposed to be temporary help. And it's turned into another backdoor way of allowing someone permanent residency here. And they take advantage of all of our public services and our systems, and they're not respectful in many cases of their neighbors. It's like it had to end.
I like how the only thing she feels she needs to apologize for after that is swearing. That's like she says, half of you don't want to assimilate. You go, where do you get that from? Like, where did all these generalizations come from? Do you know a single Haitian, Megyn Kelly? Like, where is all this information about Haitians coming from that she thinks she has in her fictional world?
You know what I'm just realizing? It's so much easier to just say stuff. Spend all this time reading and learning information to go on a podcast. You can just say anything.
The last 3 days would have been so much better if I was Megyn Kelly. But the reason I played her, apart from to show what we're dealing with, is, so main point is, I'm thinking about the people in Ohio. Let's talk about the pragmatic issues here. Someone who might know more about Ohio than Megyn Kelly is the Ohio governor, the Ohio Republican governor, Mike DeWine. This is what he says.
It is not in the United States' interest, certainly not in Ohio's interest, to have people who are working every single day, who are supporting a family, who are buying houses, fixing up old houses, starting businesses, and then put deep roots in this country and really are contributing, and yank them out. I mean, look at what the mayor of Springfield says. Mayor says that is a huge, huge mistake. They're contributing. Rob Rue says they're contributing greatly. Mistake to do that. I would cite also the 2 Ohio congressmen who have probably the most Haitians, the Republicans who have the most Haitians in their district, voted in favor of the extension of TPS. So what I would hope that the Trump administration would do is reconsider this. Look at how it's going to impact states like Ohio. In Ohio, the Haitians are working primarily in manufacturing. They're also working in the food area. But if you look at where they're working across the country, probably the most important area they're working is in healthcare. It's Haitians who many times are taking care of your mom or your dad who has Alzheimer's, taking care of family members who might be in a nursing home. And to say we're going to pull all of those out, it's just not in our own self-interest.
So yeah, policy issues. But then, need to note that this actually doesn't make much difference. If we're talking just the law here, in the long run, it doesn't make much difference. Like, there are lots of people using emotionally charged language about this decision, sending people off to death, all that kind of stuff. But if the decision went the other way, Trump would have, at worst, a few months to make a show of going through the proper process, and then the Haitians are on the plane anyway. They're still going to lose their TPS designation. At the end of the day, the law is the law. You can't challenge a determination. If the determination is arrived at through a proper process, they're going. Especially if Trump doesn't say stupid shit during those few months. In fact, if Trump wasn't so hell-bent on cutting legal corners, they would have already gone through the proper process and be on the plane already. But having said that, even now, the Haitians aren't going to be on the plane tomorrow. Many of them haven't received deportation orders yet. It's got to go through the courts, through an immigration judge, all that kind of stuff. But it does mean that within the month, most of them aren't going to be allowed to work anymore, which is going to ruin their lives anyway. And Stephen Miller has flagged that he is going to try and detain them while they're going through the system, which is lovely. But my biggest takeaway is that Alito has completely butchered the Arlington Heights test, the test of how you know whether something's racist or not. So now the standard of judging whether a government decision is unconstitutionally racist, according to Alito, was discriminatory purpose a motivating factor. It's now, can you come up with any reason other than racism that someone might have made that decision? Which very much reflects Alito's thinking in the Calais racial gerrymandering case last month as well. Alito is single-handedly tearing up all protections that the law has against racism. And the ramifications of this, they could be massive. We don't know where they're going to pop up in the future, but he's covering the board here so that it's really, really, really going to be hard to fight racism legally in the future. Thank you, Sam Alito. Do you have any other thoughts on that?
I'll make one broad observation about this court that I think applies in a number of cases, but I was thinking about it again in this context, which is ideally in a system where a court has as much political power as it does in the States, you want the court to be protecting minority interests. And I don't just mean, minorities that the left like. I mean, minorities in general. But, democracy is generally a good system, represent the will of the people. But there are times where that disadvantages people who will never be a majority in a country but deserve to have their rights protected, even if the majority, doesn't respect the rights of those people. And that's ideally what you would want a court to do, is to look out for those rights, to say, yeah, I know that the majority of people hate this religion or race or gender or identity or whatever, but, everyone deserves equal rights. And I feel like time and time again, we see decisions from this court that are very interested in protecting the rights of the powerful and not at all interested in protecting the rights of people with the least power. It's exactly the inverse of what at least I think a court should be doing. And so you see him being very sensitive to the rights of white people being discriminated against with racism and Christians being discriminated against in a majority Christian country, but not interested in protecting the rights of people of color and immigrants. And even in a case like the presidential immunity case, which you might not think of in terms of powerful and powerless, all of their priority in that case was not necessarily thinking about how do we give Trump more power, but it was, if we don't give presidential immunity, a future president could prosecute a previous president. So Trump could prosecute Biden or some other president could prosecute another one. And I'm not saying that you want something like that to happen. Like, that's not good when you have countries that are just like all, trying to jail the guy that came in before them. But what they enabled is a system, like, would you prefer, among two bad choices, a system where Trump can prosecute Biden for some bullshit or Trump can prosecute anyone in America he wants with a politicized Justice Department except for Biden because he can abuse his power with impunity? Because that's what we've got. That's not a hypothetical. That is literally what's happening now. Not entirely, but partly as a result of that ruling. And it's like, no one has to be president. I don't want presidents to get prosecuted, but if being president got a bit more dangerous, that's not the worst thing in the world. Compared, because you can choose to not be president, but you can't necessarily choose to not be the recipient of the ire of Donald Trump, especially if you are interested in standing up for the right thing and you happen to cross paths with him somehow. And so I just feel like the instinct of a number of justices on this court is always about protecting the power of the powerful and ignoring or choosing to actively take away any kind of power or protection from the people who most need protecting by these systems that are supposed to be fair. And so I just feel like that's a pattern that I've noticed, and this is as good a point of the conversation as any to bring that up, because it really pisses me off.
That's an excellent point. And the analogy to the immunity decision, I wouldn't have picked, but you're absolutely right.
It just cuts across the board in all these examples.
I think you are right. So why don't you keep on being right with Birthright Citizenship?
I see what you did there. Okay. Let's start with a little bit of background on this one.
Let's.
So on Trump's first day back in office, he signed an executive order. He signed a lot that day, to be fair, but one of them was to end birthright citizenship, which was seemingly at odds with both the Constitution and an act of Congress. So on the constitutional side, the 14th Amendment says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States.
Okay.
This is one of the Reconstruction Amendments, which gave citizenship to freed slaves. But in 1898, there was a case in the Supreme Court, Wong Kim Ark, that looked at whether this was someone whose parents had come over from China. He was born in America, so it was testing, does this apply to him? And the Supreme Court found that the 14th Amendment also extends to the children born in America to parents who are not citizens. So it's been interpreted as far back as 1898 as applying to the children of migrants, not just black slaves who have been emancipated. So, yeah, I mean, it is really worth emphasizing the Supreme Court in the 1800s saw fit to grant citizenship to anyone born on U.S. soil, regardless of the race or nationality of their parents. The only exceptions to this rule at the time, and as understood through history to date, were children of foreign diplomats, children born on foreign public ships, children of occupying forces, and members of Indian tribes, but the exception for Native Americans was removed in the Indian Citizenship Act of 1924. And then Congress passed further citizenship laws in 1940 and updated in 1952 that further codified this understanding of the law. So they basically just put it in legislation as well, among other things. But it was clearly understood to mean that there were only these three narrow exceptions to birthright citizenship. So, given the Constitution and the acts of Congress are both supposed to take precedent over executive orders, how is this even a case that made it all the way to the Supreme Court, we might ask?
Before you answer that question, can I just add one thing? That it's very fashionable when decisions become 5-4 or 6-3, depending on how you count them, for people to treat the questions with respect as if they were legitimate questions and it was a really closely run thing. But I was old enough at the beginning of 2025 to know that literally every legal expert who was worth anything whatsoever was going, this is really obvious, this question. This is an absolute slam dunk. This is a stupid executive order. Deserves no respect whatsoever. No actual legal thinkers gave it any respect at all. And now, in hindsight, they're giving it more respect because of the result in the Supreme Court. But let's remember what was happening 2 years ago.
That's a good point. It was surprising to many that this even got as far as it did because it just seemed very obvious. So what is the Trump administration's argument as to why this is even a thing we should think about? They argue we've been misinterpreting the 14th Amendment the whole time.
Everyone's been.
The Solicitor General's argument was that when it says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States, the wording subject to the jurisdiction thereof does not apply to children born to parents who are unlawfully in the US.
Okay.
So that was the key argument, even though there is evidence from debate at the time that Congress knew full well that they were extending citizenship to the children of migrants because they debated it. And some people were like, hang on a minute, this is going to give citizenship to, they were saying, gypsies and Chinese people, and other people were like, yeah, fine.
Yes.
We're cool with that. That's basically how it went, to summarize. But we're ignoring that and saying, no, actually, it was never meant for those people. It was only meant for emancipated slaves.
Sorry, can I just jump in there and also say that according to the Trump administration and the Solicitor General, there was a very important person back in 1881 who wrote a book in which he claimed the 14th Amendment should be read to deny citizenship to children of foreigners transiently within the United States. That person's name was Alexander Porter Morse, who was a famous white supremacist lawyer at the time. And he then abandoned that theory 3 years later in a speech he gave to the American Bar Association. But the Solicitor General has cited that book over and over and over again. They're quite fond of that precedent of this person's theory. But
Yes.
So there's them as well.
And the Solicitor General also made the case, which you wouldn't think would get a lot of uptake on principle with the conservative Supreme Court, but that the world has changed. And therefore, because the world has changed, we should change our understanding of the Constitution, which I didn't think we were supposed to do according to conservatives, but that's their argument. He said, we're in a new world now where 8 billion people are one plane ride away from having a child who's a US citizen, which, side note, is a very dumb argument because there's 8 billion people in the world total. They are not all capable of bearing a child.
Well, that is true.
You, Chaz, could not fly to America and give birth to a child.
That's an excellent point for so many reasons.
Not legally relevant, but just did want to point that. Anyway.
Hang on.
Yeah.
If you're going to bring that up, you need to mention what John Roberts' response to that was. Because that's the key. John Roberts' response when Sauer used that in Supreme Court arguments was, well, it's a new world. It's the same Constitution.
Yes.
Which is a key. So John Roberts' thinking versus the Trump administration's thinking.
Yes.
But yes, go on.
He was at least consistent on that principle in this instance, which was good. But anyway, we got the ruling, and it was, I would say, closer than most people expected when this was first brought up. So, but there was a bit of a wrinkle in terms of the numbers as well. So the executive order was knocked down in a 6-3 vote, which is already closer than people expected. The three who voted against were Thomas, Alito, and Gorsuch. But it was actually closer than that because Kavanaugh joined the 6-3 majority in finding that the order violated federal law, that act of Congress. but he dissented from the 5-4 majority in ruling that the executive order violated the 14th Amendment. So basically he's saying Trump can't overrule Congress with an executive order, but he does not read the 14th Amendment as giving birthright citizenship. So he says it would not be illegal for Congress to change the law to restrict birthright citizenship.
I just talk through that logic a little bit more, because some people have said, "Oh, what an idiot, Kavanaugh! The Congress and the Constitution say exactly the same thing," and so you're saying one might not mean that, but the other one does. How does that work? He actually you can agree or disagree with his view, but it's not unintelligent. His view is that he thinks that there may be potentially more exceptions available in the constitutional amendment, but when Congress legislated with exactly the same words that is in the constitutional amendment, they would have assumed the interpretation of those words were from Wong Kim Ark. And so because Wong Kim Ark did interpret those words. And so when Congress passed that law, their intention would have been to respect the decision of the court, not to undermine it or to deny it. So he's saying, well, the Congress would have thought when they passed that law and those words, it meant what Wong Kim Ark says. But my view is that Wong Kim Ark got it potentially slightly wrong. And potentially, if there was a different piece of legislation, the Supreme Court today might allow it. That's his logic. So it's not stupid logic. Yeah.
He's saying Congress respected the Supreme Court's decision, but I don't. So let me decide.
Exactly.
And legislate that.
Yes.
That's his position. And he basically says that the framers would not have anticipated significant illegal immigration, because that wasn't really a thing at the time. So they wouldn't have thought to include them in the exceptions to the 14th Amendment, but that we can assume that they would want them to apply if they looked at the situation today, even though you can equally make the opposite case that even though they didn't anticipate illegal immigration, we could assume that they would want the same rules to apply. We could assume many things.
We could. Yes.
Again, as I sort of was hinting at before, this is the same logic that conservatives and liberals argue about when it comes to guns. The framers couldn't have imagined AR-15s. Does that matter, or is the text the text? It's usually the conservatives who are saying the text is the text and you don't get to wish it away because the facts on the ground have changed. It's usually liberals saying the opposite. So I don't quite understand why we are allowed to have a different logic in this case, but some Supreme Court justices disagree with me. But Kavanaugh also effectively says all that is moot because the laws that Congress passed trump the executive order, so the status quo remains in his view from that perspective.
Yes.
But it does, that's how we get to 6-3, but it does, even that in and of itself, open this up as more of a live issue than I think most people expected when this case started.
Yes.
I want to talk about the political implications of all of this because I think this is going to be a continuing story.
Sure.
But do you want to talk more about the legal side of it?
Oh, yeah. Oh, yeah.
I thought you might.
If we're able to move into politics, then let me get back to the law. Okay. So a couple of things from Roberts's majority ruling on his justification. As you said, the key is what the term subject to jurisdiction thereof is. When he's talking about history, he had a whole sort of theory about the history. He took us through a history where he said basically this started as an English concept and it got imported through the common law because this was part of English common law originally. It came to America through the common law. And so did those exceptions come in through common law. And it was generally treated by American common law through the 1800s as if this was the rule. And then there was a very famous case, Dred Scott, in the 1850s, which basically denied the humanity of slaves. And that surprised the legal fraternity, going, oh, that's interesting. And that was part of the what led up to the Civil War. And then in the telling of John Roberts, after the Civil War, they wanted to just reassert what they thought was the law until then, which was had been until then, which was the 14th Amendment. So they passed it with the English common law concepts, and then Wong Kim Ark Wong Kim Ark confirmed them. And so he's saying, John Roberts is saying it's not just from Wong Kim Ark, it's all the way from the founding and in fact before the founding that these definitions are in place. And he says, if you don't believe me, just look at an 1865 Webster's Dictionary, which defines jurisdiction as meaning the power of governing or legislating, the right of making or enforcing laws, and the power or right of exercising authority. Not about where you live or something like that, or it was about who you're governing. Are you governed by those people? That's what subject to the jurisdiction means. He also noted in 1868, jurisdiction in a court case referred to the power of governing or legislating. So once again, he's saying both the definitions at the time plus common law at the time back this up. That's his history. Also, if we look at there's a key concept in the dissents on Thomas and Gorsuch with their alternative. Because you go, okay, if that's not the case, what's the logical alternative? Because everyone else is just looking at the wording there. What's your alternative? And they had an alternative, which was the concept of domicile. Thomas wrote a lot about this, that the 14th Amendment was supposed to apply to freed slaves and their children who owed no allegiances to foreign countries. So this is a quote from him. The same could not be said for the children of foreign temporary visitors. Foreign temporary visitors were attached to their home country, lacked similar bonds to this country, and would not be called upon in time of war. Americans, consistent with their settler ethos, believe that citizens were the people who call the place home. Accordingly, domicile, a person's legal home, played a key role in both state and national citizenship in America. That's what Justice Thomas said. And he disputed Roberts' history. He said domicile was always very important, according to him. One more quote from him. Children born to temporary visitors owed allegiance to another government, the country of their domicile, so they were not subject to the jurisdiction of the United States. Okay, so that's his concept. And Gorsuch also signed on to that. But what that means is that his domicile argument would exclude the children of temporary visitors, yes, but not the children of illegal immigrants. Because the children of illegal immigrants aren't temporary visitors. They're there for decades, right? And so Thomas and Gorsuch's definition kind of includes the children of illegal immigrants, which Trump's definition did not. This is Gorsuch. I'm going to have a big quote from him. What matters isn't whether a child's parents are citizens. What matters is whether they have made this place their home and are thus domiciled within the United States. By definition, temporary visitors to this country do not choose to make a permanent home here, and their children thus cannot claim the privilege of citizenship. And then he went on. Still, I wonder, is a child born here to parents who have long chosen to make this nation their permanent home not a citizen under the 14th Amendment solely because his parents' presence violates statutory law? If those parents are not domiciled here, then where are they domiciled? And if the answer is nowhere, how can we reconcile that conclusion with this court's long-standing recognition that every person is domiciled somewhere? So that gives a pretty strong sense where he's coming from. And Thomas also said, many others understandably have suggested that long-term resident illegal aliens satisfy the elements of domicile because they reside here with the intent to permanently remain. As Justice Gorsuch explains, the children of such aliens may be domiciled here because they are born here to parents who have long chosen to make this nation their permanent home. So what that means is Trump's interpretation of the clause, he lost 8-1. So the debate over what the 14th Amendment means probably isn't over, but Trump's take on it ain't going anywhere. I should note, though, there are problems with this domicile concept as well, which are some quick legal problems. Well, first of all, the word domicile was all over the place in the 1800s. Why didn't they use it if they meant it?
I was going to say, not in the text.
Yeah, they should have put that in the 14th Amendment. They had it. They chose not to. Why? Pretty obvious conclusion why. Roberts also noted in the lead up to the 14th Amendment, quote, no member of Congress seriously grappled with a domicile-based carve-out to the fixed, certain, and intelligible rule of the common law. if Congress intended to hinge citizenship on each individual's domicile, it's reasonable to expect there would have been at least some discussion of the topic, said Justice Roberts. And this is the biggest problem. Clarence Thomas admits the 14th Amendment was about ensuring that all black Americans, both the newly freed slaves and those who were free before the war, would be treated as citizens of the United States and of the states in which they lived. But thousands of slaves were brought to the United States illegally after the US banned the slave trade in 1808. So they were illegal and they didn't want to stay. They didn't claim allegiance to America. They wanted to go home. There's no argument that applies to those slaves that doesn't apply to the children of illegal immigrants. Try your luck. See if you can come up with one. You won't be able to come up with one. These people were illegal, just like illegal immigrants. They had no role to play in society, just like illegal immigrants formerly. They did not want to be there, which is actually a lower standard than illegal immigrants. Illegal immigrants want to be there, and they have no intention of making their home there and want to go back, which illegal immigrants don't.
Also, the idea of dual allegiance being relevant. America is a country that allows dual citizenship.
Yes.
So that's not a thing that they say in the citizenship law, that you can only have allegiance to one country, or that if you have eligibility for citizenship in another country, you are therefore incapable of being loyal to America. It doesn't apply to Trump's kids, for example.
That's an excellent point. But anyway, my point is that domicile doesn't work for the slaves. And one thing that everyone agrees is that the 14th Amendment is supposed to protect the slaves and their children, right? So the domicile people have a real problem there.
And there was also the question raised of, if that's going to be the standard, how do you define domiciled? How long do you have to be in America before you're domiciled there?
That's true. It's a very subjective thought.
What is that test?
Yeah. Alito, for his part, wasn't into domicile. He was into allegiance, which you've already taken care of. I won't even go there because his arguments are kind of lame. But he was obsessed with birth tourism. He was. Let me read you one of his quotes. Basically, his ruling was very consequentialist. Just him saying illegal immigration is bad, birth tourism is bad. Let's stop it. Here's the quote. Suppose the person's only connection to this country is that he was born here to a mother who was present just long enough to give birth and then quickly returned to her native country. Suppose the country is a strategic adversary or enemy of the United States. Suppose the child never visited the United States while growing up and was inculcated with hatred of this country. According to the court, this person is a citizen of the United States. He can enter and leave the country as he pleases. He can travel the world on a United States passport. Even if he plots to harm this country, he cannot be deprived of his status as a citizen, at least under current precedent. And not only is that flatly a policy argument and not a legal argument, and so he should just run for office, I think there are loads of people who would be fine with eliminating that option as a policy. No one's saying, oh, that sounds great. But judges know that the law doesn't work that way. You have to look at the text. And if that thing you want isn't there, then you campaign to put it there. And then the judge can say, look, that's there, rather than just making it up like Alito just did. Trump's having a bitch about this himself. He tweeted out, I would like to congratulate President Xi and the great country of China on their massive birthright citizenship win. But I just want to point out, on the legal side, Trump ruined this. It's Trump who ruined this, like right here, because it was Trump who tried to overturn a constitutional amendment with an executive order. And it was Trump who made the exclusions as broad as possible so that even Gorsuch and Thomas wouldn't accept them. They were never going to remove the future citizenship of the children of illegal immigrants who don't belong to any other country and grew up in America. He lost that question 8-1. But if there was a law that was stopping birth tourism, maybe the Supreme Court might have passed that. We'll never know because he didn't try, and now he's made it almost impossible for him to get anything done. That's my end of my legal stuff. You go to the politics.
Well, also just because we've just finished talking on birth tourism, there are ways to stop that or at least limit it other than ending birthright citizenship.
Yeah, you can use the police. It's against the law.
Yeah.
Yes.
And also that's, in the scheme of things, it's estimated about 10,000 children a year are born in those circumstances, the sort of birth tourism. And it is a thing. There are, companies overseas that, arrange specifically, but it's a small thing It's a big issue with children of illegal immigrants. That's estimated. Ending birthright citizenship would affect around 250,000 children born in the US each year. That's not nothing. And I think that kids being born in America to parents who don't have legal status and therefore having different legal statuses is a policy problem to an extent. Like, that creates problems. It's difficult for those families. It creates problems in terms of, we're seeing it in the enforcement of immigration law, where you then do you separate a family? You have the arguments over should you give legal status to the people who have kids that are citizens because of birthright citizenship? Questions like that. It does create complications. But having more guns in a country than people creates problems as well. Yeah. The fact that it's inconvenient or there's maybe a policy question there doesn't negate the law. And I just feel like there's this real culture now that doing a constitutional amendment is hard. And everyone's like, that's impossible, especially in these polarized times. And even passing things through Congress is hard. So rather than trying to change the Constitution when we don't like it, let's just change the court.
Yeah.
Let's just try and get the judges we like and see if they'll just make some stuff up that sort of suits us. And that's not how the system is supposed to work. So that's a problem. But people have, because this ruling was closer than expected, gotten a taste for some political blood in the water. And so this thing that from the beginning everyone was like, this is just nothing. This is going nowhere. There's a real feeling now that this is going to pick up steam as a political issue, even though actually changing the Constitution is very unlikely to happen anytime soon. So in terms of the political reactions to the ruling, it's fair to say a lot of right-wingers had meltdowns over it. An example, Matt Walsh of the Daily Wire said, "I at least got to live for 40 years in a country that looks and functions something like America. The fact that my children are having that opportunity stolen from them fills me with rage so deep I can't describe it. I truly hate the people who have done this to us." To which many people reminded him, this ruling doesn't change anything. It just upholds the status quo that's existed for over 100 years. Nothing's changed. It's the same America that you grew up in, Matt Walsh. So what in the world are you talking about?
That guy is pretty unhinged.
But there was that's like that reflects the tenor of a lot of commentary online. But then even from people who in theory should be more serious, like Mike Johnson, speaker, said, "Today's ruling is antithetical to the rule of law and endangers our national security. Our country should be under no obligation to permit illegal immigration to America for the sole purpose of engineering citizenship. This issue is too important and too precious to get wrong. Unfortunately, that's exactly what the Supreme Court has done." This has nothing to do with permitting illegal immigration. You can stop illegal immigration. Yeah. Have all the policies you want to stop illegal immigration.
Oh, they do.
This is saying, if the child of an illegal immigrant happens to be born in America because you failed in your policy of stopping illegal immigration, they get to be American because it's in the Constitution.
There's so much cynicism too. Like Ted Cruz is saying similar kinds of things, even though he's on tape saying that basically this is just a slam dunk, back in 2011. He's just done a complete 180 now. It's politically convenient. I can't believe, by the way, that if you're going to quote a crazy, you quoted Matt Walsh rather than Sean Davis, the editor of The Federalist, who literally presented 7 options for people. And the options were nullification, which is just just ignore the Supreme Court, pack the court, deny entry to all pregnant foreigners, deny entry to all female foreigners, require sterilisation of all foreign visitors, male or female, prior to entry, dissolution of the union, because a nation which can't even restrict who gets to be a citizen isn't a nation, and finally, amend the Constitution. This is pointless because once a judge decides he can rewrite the Constitution at will, as Roberts and Barrett did today, the actual text is meaningless. But this is what most GOP politicians gravitate towards because they're useless. Extraordinary how butthurt these people are. I mean, honestly. The left haven't won too many battles from the Supreme Court. No one's acting like this. These guys, this is the one issue they get very, very, very worked up on.
Yeah.
The great replacement theory. That's what they get worked up on.
Funnily enough, this case, as it was going through its process, seemed to be so important to Trump that he became the first sitting president in history to attend oral arguments at the court for the case.
Yep.
But when the result came out, he seemed kind of uncharacteristically chill by Trump standards. So
yeah, he was.
He truthed out.
Yes.
The Supreme Court upheld birthright citizenship, which is too bad for our country, but we can easily make it up in Congress through legislation with the support of the president that has now been determined during this process. No long and unwieldy constitutional amendment is necessary. Congress should start today to work on ending expensive and unfair to our country birthright citizenship. They will have my complete and total support. President Donald J. Trump. Okay, that's wrong.
Yeah.
We should say, because it was still 5-4 ruling that birthright citizenship is constitutional. So even if Congress passed a law, they've shut the door on that in the most immediate sense. It is an interesting counterfactual, I think, to wonder what might have happened if Trump had actually gotten Congress to pass a law restricting birthright citizenship rather than do it in the laziest possible way through an executive order.
Totally.
Could the result have been different? I think it's not. There's a non-zero chance there might have been a different result if it felt that easy, if it wasn't such an egregious undermining of...
Yeah, I think if they passed a statute that was just about banning birth tourism and only birth tourism, I think they would have got away with that. I can totally see how you could make the argument that this was not envisaged back in 18 whatever, and and this is the tiniest exception, and that this this doesn't fall under subject to the jurisdiction of like when someone's only in the country for a couple of days, and then they go to another, like you'd have to have some kind of they can't be in the country for less than 3 out of the first 5 years of their life, plus only being in the country for 2 weeks, like for less than 2 weeks after they were born or whatever. You have to have some very finicky way of demonstrating it. But if that's what they'd legislated, I reckon they could have got away with it. But Trump doesn't want that.
Yeah.
He wants to get rid of illegal immigrants. so there's a good reason he didn't do that.
Yeah.
Yes.
But yeah, it's kind of interesting that he wasn't more worked up. And I tend to agree with the thinking that the ruling is kind of good for Trump because he kind of gets to avoid the chaos that overturning birthright citizenship would cause, but he gets to keep it feeling like a live issue. Yeah. And, a lot of people are saying now, like, this could be the new Roe v. Wade, where it becomes a litmus test for right-wing judicial nominations of, would you support overturning birthright citizenship? And like I say, changing it by constitutional amendment, not going to happen. Changing it by Congress, unlikely to happen anytime soon. But the idea of we had 5-4 of it being just a congressional issue.
Yeah.
You only have to flip one more judge and you might have a majority for that position. And then you only need Congress to write a law to say not just ending birth tourism, but ending birthright citizenship for children of illegal immigrants. And so the fact that it feels achievable, it feels within the realm of possibility, means that it becomes a charged issue, and people who like to talk about illegal immigration and whip up a lot of conversation and, some might argue animus around this issue, can run with that now and continue it. And Trump can keep bashing it, saying, you got to vote for Republicans because we need to change, we need to flip these judges. We need to pass these laws. We need to change this rule because, we're just one vote away. So I think that this is annoyingly not going away.
Yeah, I agree. I think what you just described is exactly what's going to happen. I think it's a perfect political issue to kick around.
Yeah, and for what it's worth, it's also going to be annoying that for a lot of people on the left, this is suddenly going to become a really important rule where they're like, look, for the kids who are born to illegal immigrants who grow up in America, I think it's a good thing that they have citizenship. But, I would not be surprised to see a lot of people suddenly treating this like this is some sacrosanct rule. And it is worth saying about 30 countries in the world have birthright citizenship. Australia is not one of them. Most Western countries have changed used to have it and changed the rule in the past few decades. Most in Europe, Australia used to have it, doesn't have it anymore. There are sometimes odd outcomes. Like I have a friend who, he's German and his whole, so grew up in Germany, his whole family grew up in Germany. For 1 year, it was not birth tourism, but his dad got a temporary job for a year in America. And he's one of 4 kids. And he happened to be born in the year that his dad was working in America. So he has an American passport. And he lived there for 1 year as a baby, and then they moved back to Germany. He grew up in Germany. He doesn't remember being in America. He did as an adult work in America for a few years because he probably would have been able to get a visa anyway, but easier if you have a passport. He keeps the passport because it's a handy thing to have. He doesn't live there now. He lives back in Europe. But it is one of those weird things where it's like, there's not really a policy argument for why he should be an American citizen. It's nice for him. It doesn't hurt anybody. He's not taking advantage of it or, so who cares? It's certainly not, I think, of all the problems America has, that doesn't strike me as a priority. Yeah. But, birthright citizenship can sometimes have these weird things where I'm like, you don't need that. Like, I'm not going to, die in a ditch defending that as a policy issue. But I think it is going to start to become a thing that people, gets codified as you must have a strong position on this. In the same way that a lot of right-wingers probably didn't care about this 5 seconds ago, and now it's sterilize people and close the border. And yeah, it is, talk about raising the stakes of inconsequential views.
Yeah.
This is something that didn't need to be a big issue that is now going to become something we have to hear and talk about a lot.
Yeah, look, my personal view, I don't care about birthright citizenship at all. I think the children of illegal immigrants should be citizens.
Yeah,
I don't think it works well in Europe at all, having literally hundreds of thousands, if not millions, of stateless people just sloshing around, not being able to work.
Yeah,
that's not good for racial harmony in Europe. And I think America is more successful because it's not like that. But I don't think. I think if you have no connection to the country whatsoever, if your German friend, I think that they shouldn't get automatic citizenship. Well, I don't care.
Yeah, I don't care.
I actually don't care. But in fact, it's tough now because Trump's buggered it up for everyone. But if there was a way that you could go back in time, forget Trump and get them to do it right, get the Democrats to pass legislation to basically get rid of birth tourism, I'd say do it. Because that's a distraction you don't need. And that's what they're going to focus on. But you can bet your life Fox News is going to be making that, that'll be the new illegal crime. Birth tourism. They're just going to go on and on and on about it. It turned to this huge calamity that's just an emergency situation. Just get it off the table. It's not help. No one wants it. It's not going to help anyone. There's no advantage to it at all. If you get rid of that, I'd love them to get rid of that. Sadly, we're not in that world, and we're going to be having this argument for decades.
Yeah. I also think in terms of the fallout from this, we can expect more novel legal arguments and cases because this court has proven willing again and again lately to push rulings a lot further than anyone would have thought when the cases were brought. Even with something like Roe v. Wade, thing we shouldn't be shocked, but it keeps happening that we're getting results that are surprising, and it encourages a cycle of pushing the boundaries more and more, especially with Trump, but I think that's going to continue beyond him. Clarence Thomas noted in his dissent, the president's initiative generated a groundswell of new scholarship. Well done, Mr. President. Thank you for this new scholarship around a really seemingly clear and obvious law that I felt we didn't need to argue about.
I think I'm really glad you brought it up because I forgot to mention that. Okay, Kavanaugh, I'm not thrilled with, but fair enough. I can see where he's coming from. Gorsuch, Thomas, Alito, honestly, they should be ashamed of themselves. If you, I understand hacks, all the rest of it, I get it. But if you are saying that executive order didn't at least contradict the statute, that you shouldn't be a judge. You should have to turn in your bloody robe. That is so bad. That's terrible judging. It's just, I mean, I personally think that even Kavanaugh's was not great, but you go, okay, look, there's a bit of subjectivity about these things. I can understand, like the argument he's coming from, whatever. That's reasonable. That's not an unreasonable argument. But it is extremely unreasonable to say that Trump's executive order should trump legislation from the 50s. Like, that's just, it's inexcusable. And I'm gonna have another one of these later on, where there are a couple of these decisions where I just go, well, we're really close to Hacksville here, like really close. I mean, I haven't forgotten or forgiven the immunity ruling, but like in some of these cases you just go, well, there's no point having a Supreme Court if they're going to ignore the law to this extent. And so I would say on the case of the three, we're at that point. I'll come up to the fourth later on.
I've sort of already noted it, but I do think it's a problem that political culture now is increasingly trending towards just trying to get things done through the Supreme Court. That, all we have to do, you don't have to worry about the legislative process anymore. We don't need to worry about convincing people. We just need to get our judges in and then do a shortcut executive order and get them to come up with some kind of stretch of an argument for why it's actually fine. And that's the law now. And it's like, what a terrible way to run a democracy, just between a president and a court, just completely circumventing the people's representatives.
Yeah, I know. I mean, look, this is part of what happens when Congress doesn't work anymore. People feel there's no other option. But it's all much of a muchness of the Supreme Court becoming the last functional branch of government to become dysfunctional. And it's well on the way. And, should we move on to slaughter?
Let's.
All forms of the word. Okay, so background. From the beginning of Congress, the founders argued about who should have dismissal power for executive appointments. At the time, they had state departments, war departments, and treasury departments. Pete Hegseth was happy about that. And Congress were arguing whether the foreign secretary could be sacked by the president alone or would it require Senate approval. They didn't know, and they just passed the Constitution. It wasn't clear. Alexander Hamilton was vociferously on the side of requiring Senate approval to dismiss the foreign secretary. He lost the debate in what people today call the decision of 1789. I can't emphasize enough, these people literally just wrote the Constitution and they didn't know the answer to the question for sure. You'd think that would lead to more modesty today. No such luck, as we're about to discover. Congress was given permission in the Constitution to form agencies to help it perform its job, and they started to do that in the late 1800s. Then in 1926, there was a case called Myers versus the US, which wasn't explicitly about congressionally created agencies, but the former president was the Chief Justice at the time, Howard Taft. He argued that a law limiting the president's ability to fire a postmaster was quite out of keeping with the plan of government devised by the framers of the Constitution. He argued that since the president's selection of administrative officers is essential to the execution of the laws by him, so must be his power of removing those for whom he cannot continue to be responsible. He didn't mention agencies. Just note that. 9 years later, when many of the same justices were still on the Supreme Court, we had the Humphreys executive case, which is about FDR wanting to fire the head of the FTC. That's the Federal Trade Commission. They held the Federal Trade Commission is an administrative body created by Congress to carry into effect legislative policies embodied in the statute in accordance with the legislative standard therein prescribed, and to perform other specified duties as a legislative or as a judicial aid. Such a body cannot in any proper sense be characterized as an arm or an eye of the executive. Its duties are performed without executive leave and in the contemplation of the statute, must be free from executive control. To the extent that it exercises any executive function, as distinguished from executive power in the constitutional sense, it does so in the discharge and effectuation of its quasi-legislative or quasi-judicial powers, or as an agency of the legislative or judicial departments of the government. So, because FTC commissioners occupy no place in the executive department and exercise no part of the executive power vested by the Constitution and the President, Congress could limit their removal to for cause. Note, 4 of the justices who signed Humphreys also signed Myers. Okay, they didn't suddenly have dementia. They didn't want Myers to be misconstrued as extending down to all at-will presidential appointees. And so Humphreys limited it severely. Then in 1988, Scalia wrote a sole dissent in a case in which he quoted Article 2 of the Constitution, which reads in part, "The executive power shall be vested in the President of the United States." And he said, that quote does not mean some of the executive power, but all of the executive power. That's called the unitary executive theory. The president should exhibit all the executive power. And that time was very controversial. If the founders meant for it to be all of the executive power, why didn't they say that? They had the word all back in the 1780s. Especially as they explicitly in the Constitution mixed some of the heads of power amongst the 3 heads of power. The president is involved in the legislative process through veto. The president can't pick principal executive officers without the Senate's approval. The president takes the lead in foreign policy but can't make treaties without the consent of the Senate. Congress creates every court except the Supreme Court and can limit the High Court's jurisdiction. That's all baked into the Constitution. That's what they wrote. They intended to mix them up a little bit. Alexander Hamilton himself in 1788 specifically declared that, quote, "the executive authority is divided between 2 branches." But apparently the originalists on the Supreme Court know more about the Constitution than Alexander Hamilton did, apparently. And that leads us to this case now. Trump fired Rebecca Slaughter from her position as one of the Federal Trade Commission's 5 commissioners. That was even though her 5-year appointment was not due to expire until 2029. By the way, she was in her 2nd term. Trump appointed her in 2018. But anyway, federal statutes restricted the president's abilities to remove an FTC commissioner except for cause. For cause means only for inefficiency, neglect of duty, or malfeasance. Trump fired her, stating her service was inconsistent with the administration's priorities. Last July, lower courts blocked Trump's sacking because he failed to comply with the removal protections set out in the statute. The DC Court of Appeals upheld that ruling 2-1. And then we go to the Supreme Court case, which was ruled 6-3, once again, along partisan lines, with Roberts writing the majority, and he came out hard. Here he goes. 100 years ago, let's get the music going, Lockie. This court honoured the convention's choice in the seminal case of Myers versus United States. There we held that the Constitution grants the president the general administrative control of those executing the laws, including the power of appointment and removal of executive officers. Because no one could execute the laws alone and unaided, Chief Justice Taft explained for the court the president must be permitted to select those who act for him and remove those whom he can not continue to be responsible. To hold otherwise would make it impossible for the president to fulfill his constitutional obligation to take care that the laws be faithfully executed. So right away he's placing a spin on the Myers case that the judges in the Myers case themselves didn't seem to have. But he continued, since its creation in 1914, the FTC has accumulated vast rulemaking, enforcement, and adjudicatory powers under more than 80 statutes. Not only does it promulgate rules that carry the force of law, but it also enforces those rules against private parties collecting civil penalties in the billions of dollars. Its powers, however, do not belong to the president or his appointees alone. They instead belong to 5 commissioners, each of whom serves for 7 years and may be removed by the president only for inefficiency, neglect of duty, or malfeasance in office. We hold that such protection from removal is contrary to the separation of powers enshrined in the Constitution. So he's taken a body that was created by a legislature to construct rules for a legislature. It's trade, right? That's a congressional power, not a presidential power. And he's given it holus bolus over to the president. This body controlling trade, which is a congressional power, doesn't care. And he says he's doing that to help the separation of powers, handing over something which is entirely about congressional power over to the president. Yeah, that's going to help. And he said he did that because of the 80 laws passed about it, i.e. the legislative process, which, by the way, the president took part in. And then he finished off. Although it's up to the Senate to decide whether to confirm those with whom the president would prefer to work, neither Congress nor the courts may saddle him with those with whom he cannot work. Subordinates who exercise the president's power subject to removal by him, then and only then can they remain accountable to the president and the president to the people. So presidents can only remain accountable to the people if they can fire the FTC chief. It's the only way. Until now, presidents haven't been accountable to the people, apparently. I've got a really simple question, Melina. If the FTC is exercising the president's powers that have unconstitutionally been handed to them, then why not remove those powers? It's called severability. It's a completely normal procedure on the Supreme Court. They go, you have these powers you're not meant to have, we're taking those powers away from you, and we'll leave you untouched otherwise. Just the bit which is unconstitutional we'll take away. They could have done that. It's almost like Roberts and friends wanted to give the president more power. And so they just gave him a whole lot of stuff that had nothing to do with him, rather than just cutting away the stuff that a non-executive body shouldn't have. What are your thoughts so far?
Yeah, I mean, I feel like Congress designed these agencies to have certain powers and independence from the president. And now the court says that they can keep the powers but not the independence.
Yes.
And that raises the question, would Congress have given the agencies these powers if they knew that it was the president that would have the power to control them and that they wouldn't be independent?
Yes.
That, I think, is a question that's worth answering. Instead, the court's redesigning the nature of the agencies that were created by Congress and just, again, coming in with a we know best. We're gonna design these the way we like them, rather than the way Congress designed them, even though, as you say, it's Congress's jurisdiction and they are supposed to be a co-equal branch of government.
You know, that point you raise is a great point. And it was also raised by Sonia Sotomayor, who wrote the dissent. Why don't we just go straight into what she said? Seldom, if ever, has this court worked such a profound bait and switch on a co-equal branch. For more than 90 years, Congress believed with this court's express approval that it was allowed to create a workable government, including by granting certain agencies tasked with certain responsibilities some independence from presidential control. In rejecting that project, after decades of promising the political branches that structures like the FTCs were permissible, the court creates an executive branch that Congress never dreamed of establishing and that now has little hope of ever reining in. She agrees with you. You should be a judge. Now, I should also say with Sotomayor, she went through the history a lot and showed that this theory has no support at all. She did a pretty good job of that, actually. And just said the result is a president who emerges with far greater power than ever before. It's a power, however, that neither the people nor Congress nor the Constitution bestowed upon him. Before I go into Gorsuch, who strangely agreed with Roberts, but backs up Sonia Sotomayor's point. That's a weird flex from him. I just want to make one other legal note on Roberts, that what he's done is he's kind of dumbed down the Constitution. In Humphreys, the court distinguished between an administrative function, which the executive branch helps with, and actual executive power in the constitutional sense. They explicitly distinguish between them. And that's how most people have seen the Constitution for 200 years. But Roberts has collapsed all powers. He's removed administrative completely, and he's just collapsed it into legislative, executive, or judicial. That's new. No one thought like that until just now. Roberts would argue he's removing a fourth branch of government that was completely unaccountable and not mentioned in the Constitution. That's undoubtedly what he'd say. But what he's actually done is he's made sure that the president controls all executive power, but Congress doesn't control all legislative power, and the courts don't control all judicial power. There is zero constitutional basis for what he's saying, other than Scalia's single assertion about all the power, which he has no evidence for.
And, quick side note on that. That's why I was sort of a bit, when you were talking about birthright citizenship and saying, oh, actually it's 8-1 saying that children of illegal immigrants are citizens. I was like, Well, it is now, but, judges leave these breadcrumbs so that and I think that's Ketanji Brown Jackson's project at this point as a minority judge on the court. Minority, I mean, in the sense of liberal, not racial. But, they leave these breadcrumbs so that when the winds of politics change, people can pick up things and run with them.
That's true.
And so I'm probably a bit more concerned about. I'm not quite as confident that that 8-1 is going to stay 8-1 over time, because but it is also kind of crazy to take something that was the 1 in an 8-1 decision and refer to it as if it's legally meaningful to justify your argument today.
Yes. No, that is true, and it's a fair point you make about birthright citizenship. Let me remind you, not only is there no constitutional basis for this theory, the unitary executive theory, but the framers themselves vigorously disagreed on the subject of presidential removal power. I'm talking about unitary executive, even removal power, they vigorously disagreed on. But what's happened now is Roberts has expanded it, despite the fact the Constitution explicitly authorises Congress to establish federal agencies and to define the scope of their mandate. So it's a lot shorter walk to say that the agencies were doing what the Constitution said than Justice Roberts is doing what the Constitution said now. Because the Constitution explicitly allowed Congress to do what they did. Constitution doesn't say anything about what Roberts is doing now. But Roberts ignored that in favour of his made-up right of the president to remove agency heads, and the court wants to reinvent the entire country around that made-up right, which might work out fine. Maybe it will. Maybe it won't. Let's go to Neil Gorsuch, who I said before, had this weird sort of straddling both sides.
I got a quote from him in my...
do you want to roll into him? Do you want to go into it?
Sure, I'll do Gorsuch. I was just going to note that he talked in his ruling about the possibility of a president using total control over agencies to carry out retribution against his enemies.
Yes.
Why would anyone worry about a president being interested in that? Anyway, he says, a business out of favor with the party in control of the White House might be able to stave off an FCC investigation, but can it survive a subsequent FTC rule declaring unlawful one of its long-standing trade practices? What about an in-house adjudication by OSHA? Or a prosecution for a new crime the SEC announces? This is from a guy who ruled in favor. Yeah. Those are good questions. What are the answers?
These are great questions. He finished off that thought with, it may be true that after today there is no more fourth branch of government, but the fourth branch's powers still exist. They've just been reassigned to the president. Once again, sounds like a dissent. He also said, today independent agencies do not just exercise executive law enforcement powers. Congress has also delegated to them vast legislative and judicial powers, effectively allowing these agencies to make laws and decide disputes under them. And after today's decision, the president can effectively exercise all those powers too. And finally, he suggested these might be the worst fears of the founding fathers. This decision he signed on to. He said, while electoral accountability is a good thing, it can't be the only thing. And allowing presidents to control not only executive functions, but also vast new reservoirs of legislative and judicial powers risks inviting exactly what those who framed our Constitution feared: the accumulation of all powers in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective. What the hell, Gorsuch? Turns out, though, Melina, Neil Gorsuch has a plan, because he proposed a solution. It's pretty exciting stuff. His solution is the Supreme Court needs to take more power. That's his solution. From here, the only sure path is to finish the journey we start today and restore legislative and judicial powers to where they belong, in Congress and the courts. We have tolerated adventurous theories long enough. It's time to return all the way to the Constitution. And then he spelled out what he meant by that. He means, if any real response is to come, he said, it will have to come from this court, this Constitution. The Constitution provides a blueprint for the job ahead. He went on then to talk about the non-delegation doctrine, the major questions doctrine, the vagueness doctrine, Loper-Bright, all of his favourite new toys. By the way, for someone who cares about the major questions doctrine, and I'm favourable to it, aren't the workings of the entire government for the last 100 years kind of a major question? So shouldn't you really be changing that with basically no textual justification whatsoever? Shouldn't you need the text to be really, really clear to do that? Because that seems like a major question to me. I have to ask Neil. He's the expert on the major questions doctrine. But he's got a thought for the left who don't like all those doctrines. He says, removal protections are now a thing of the past, and the president enjoys direct control over independent and executive agencies alike. So even if entrusting legislative and judicial powers to insulated independent agencies once seemed like a good idea to some, it's simply not an option anymore. Now we face only two ways forward. Let presidents exercise all those powers or begin subjecting them to the Constitution's constraints. We broke your government. Now the only thing that might fix it is us. So get on board. That's not a quote from him, but it might as well have been. To me, this is hugely irresponsible. It's a massive power grab from Neil Gorsuch, and it's forcing the country to start a journey that in all likelihood they're never going to finish. This is a 50-year project from him. They're going to get maybe a quarter of the way through it. I mean, the other judges don't necessarily agree with his project for a start, but then, the judges will change over time. In 10 years' time, in 15 years' time, they're going to drop this project. They'll move on to something else, and it'll be halfway through, and they will have buggered up the country, and they won't have time to fix it up. Pisses me off. What are your thoughts, Melina?
I think the idea of just, Congress, take your power back is a nice idea in theory, but in practice, you have to, and they noted this, I believe, in the dissent, it's that they only required a majority of Congress to set up these agencies, but you need a supermajority to get past a presidential veto. And what president is going to give up these powers? Yeah. And it's not even a partisan thing, because the next Democratic president probably also will be happy to have these powers. Mm. And so the idea of Congress, you shouldn't have given them those powers, take them back. It's okay, cool. That is not realistic.
No.
And when there was an option, as you were saying before, of just carving out the things that were not appropriate, there's just the lack of modesty with this court. It's rather than doing the least they can do to affect a legal outcome, they are very interested in executing these, I shouldn't use that word in this context just because it's confusing, but enacting these sort of broad legal theories and changing the nature of America and American government through their power when they're 9 unelected people. Yeah. They have the least legitimacy when it comes to basically controlling how America operates. And yet I feel like they're in this theoretical co-equal branches of government, they are really increasingly asserting themselves, not for the first time in history, but certainly increasingly so, on top of the other branches with this, we know best attitude, and we're going to just come in and say, tear it all down. And if you'd like to rebuild it, go right ahead. It's
I agree. Now, I want to turn the temperature down a little bit here. We don't know how this is going to play out. This might do nothing, because presidents already had huge influence over regulatory agencies. That's part of what makes it so stupid. Their suggestions, the president is hostage to these regulatory agencies who are just doing whatever they want. That's not how it works. Presidents appoint commission members. In the last year or two of their presidency, they usually have appointed a majority of the commission. They designate each commission's chair, who they can replace anytime they want for any reason. They control agency budget submissions to Congress through the OMB. Over the last decade, agencies have very much followed the president's desires. They don't seem very independent to me. So maybe the sacking authority isn't going to make any difference. It really depends how the president uses it. These are meant to be bipartisan commissions. Is the president now going to just trash that and just appoint 5 hacks? That will make a difference. Is that what they're going to do? We don't know. Are they just going to shoot? Are they going to just swing for the fences now? Are they going to get rid of the experts? Because there used to be experts on these commissions. Are they just going to put hacks on? There's just going to be Bill Pulte on every single commission? I guess we'll find out. We don't know.
Well, and the other, you might be about to go here, but the other option is that some agencies can only act with a quorum. So a president can hollow out an agency by firing commissioners it doesn't like and not replacing them.
Yeah,
and
which
just
is what Trump did.
Functionally shut down the agencies.
Yeah, and Trump already did that. Like even before this, he did that.
Yeah.
So I mean, they could do it. They might. We don't know. We don't know how they're going to deal with this. I mean, some say that this could be more useful to Democrats because Democrats use the agencies more than Republicans do. So Republicans don't need that power. The Democrats can use that power to stack it with their people and then go hard with these agencies. That's what some Democrats are saying. I wouldn't count on that because what could easily happen is there's no more experts, all hacks, 2 sets of hacks flipping back and forth, destroying any stability in the government. That's not going to help anyone. The big question for me on this is how far does this go? Because Roberts does something in this ruling which is particularly worrying. And it has to be intentional because it's Roberts. He knows what he's doing. He hasn't distinguished between inferior officers, civil servants, or administrative adjudicators in this. He just asserts that the subordinates who exercise the president's power are subject to removal by him. What does that mean? Does that mean civil servants, all civil servants? Sotomayor was right across that possibility. She wrote, today's decision may also have major implications for inferior officers and civil service employees, which the majority studiously ignores. They get those dissents beforehand, and Roberts didn't reply to it. He didn't address that at all. He just silenced. Even in Myers, Taft explicitly wrote, Congress, in committing the appointment of such inferior officers to the heads of departments, may prescribe incidental regulations controlling and restricting the latter in the exercise of the power of removal. The reason he did that was so there'd be no confusion that he didn't think the executive power of removal reached down that far. Roberts included no such disclaimer. That's not an accident, Melina. He's put those kinds of disclaimers in the past, and this time he chose not to. And can I just say, if they do intend to allow Trump to fire bureaucrats without cause, that would be even more completely divorced from any text or precedent ever. This case might do nothing, but it might also have the biggest tail of anything the Roberts Court has done, including the immunity ruling, depending on how these things play out. We just don't know. This could be massive. This could explode the government and just destroy the country's administrative system. It might do nothing. We don't know. This is a gamble they are taking with their hubris. Do you have any thoughts?
No, that's just a very broad range of outcomes. I don't know how to feel right now.
Yes. Okay, well, let's go into Cook quickly. Trump tried to fire Federal Reserve Governor Lisa Cook over dubious mortgage fraud allegations. She challenged the sacking in court because of the for cause requirements. Very similar to Slaughter, except it was the opposite result. Roberts allowed it. He wrote, the court decides this application on the narrow ground that the president failed to afford Cook the procedural protections to which she was entitled by statute. Without such protections, she could not properly dispute the charges the president laid against her. It's interesting that he said she was entitled to procedural protections by statute, but then the protections he required weren't in the statute. He said, at minimum, Cook was entitled to some explanation of the evidence at issue, some avenue for a response, and a deadline by which a response would be due. Now, Roberts emphasised he wasn't saying Trump couldn't sack her, just Trump had to follow basic due process. Okay. The question then is, why does Lisa Cook get due process, but Rebecca Slaughter not get due process? Roberts really emphasised the double standard with this. Congress limited the president's power to remove governors for good reason, to preserve the independence of the Federal Reserve and to continue the long tradition of monetary policy exercised independent of executive influence. Any change in that scheme must come from Congress, not the courts. Yes. And Congress also limited the president's power to remove FTC commissioners for good reason, to preserve the independence of the FTC. Why mustn't a change in that scheme come from Congress and not the courts? Well, previously the Supreme Court has suggested that members of the Federal Reserve are immune to the unitary executive because the Federal Reserve is a uniquely structured quasi-private entity that follows in the distinct historical tradition of the first and second banks of the United States. I don't know if anyone knows what that means, even now. But Roberts really doubled down on that gobbledygook in the court case. He spent 6 pages laying out the history of federal banks and financial panics to show the first bank and the second bank were very important. Few problems with this. One, why is continuity with the first and second banks of the United States so important when it doesn't even appear in the Constitution? Neither of them are mentioned in the Constitution. They were formed after the Constitution. So why is he so obsessed with them? Number one. Number two, why is continuity with the first and second banks of the United States so important when many of the founders, including James Madison, Thomas Jefferson, and the first Attorney General of all people, they believed that the Bank of the United States was unconstitutional? And yet John Roberts says, this is very important. We follow in their tradition. And three, as Clarence Thomas wrote about at length in his dissent, what does the Federal Reserve have to do with the first and second Bank of the United States? They were very, very different from the Federal Reserve. This is Roberts' response to Thomas. It's true, of course, that this tradition has not stood still. As Justice Thomas notes, the Federal Reserve is more powerful than the predecessors, managing a vastly more complex economy in a vastly more complex world. We see no reason, however, why our central bank ought to be trapped in amber any more than any other aspect of our constitutional scheme. What matters is that the Federal Reserve remains consistent with the principles that underpin the first and second banks, namely, monetary policy should not be subject to political interference. So that's how he answers Thomas. Sadly, there are no answers to my questions. Anyway, because the first and the second bank in the United States is so important, and because they're kind of like the Federal Reserve, that's good enough for Roberts to explain why the Federal Reserve is an exception to the rule that the Supreme Court passed 5 minutes ago. Melina, your thoughts so far?
Yeah, it sounds a little bit like consequentialism, doesn't it?
Just a little bit.
One of those things, eliminating the independence of one of those things would have worse outcomes for the US economy than the others, and suddenly they care.
Yes.
I mean, yeah, look, it's not like these are the first justices that take the outcome that they want and work backwards from there to, but it's just like, look, I'm personally the kind of person who isn't like someone said something hundreds of years ago and you should never update your understanding no matter what in the world changes. Like you should be bound to like a handful of guys from a different time, no matter what perverse outcomes. Like, that's not my judicial philosophy.
Yes.
But it is their judicial philosophy, at least in some cases, that I don't like from a policy outcome. And it's just quite galling when like the hypocrisy is so overt. And it's just so obviously based on, well, we don't want to mess up the Federal Reserve and send markets spiraling. So let's concoct some just completely random reason why we're going to rule different when, as you say, quite similar cases.
Yeah.
On the same day.
So you are kind of asserting, without any evidence, that that's what they're thinking. So let me provide the evidence for you. In the form of Brett Kavanaugh's opinion, who just didn't beat around the bush. He just came out and said it. After slaughter, there's a clear choice. Either the Federal Reserve may remain independent with the governor's removal for cause, not at will, or it may not. Leaving that question open would create significant uncertainty about whether the court might soon eliminate the Federal Reserve's independence and thereby expose the Federal Reserve to political influences and jeopardize the efficacy of US monetary policy. Even temporary uncertainty about the status of the Federal Reserve could spark political upheaval, including confusion about whether the president could immediately remove multiple governors at will, as well as turmoil in US and world economies. I would not go down that road. I would not risk destabilizing the US economy just so that we can further mull over an issue that in various permutations we've been thinking about for many years. We could further mull. That's what they were doing in slaughter, apparently. They were just mulling over an issue. So he openly admitted it's a policy decision. And he seemed comfortable with just owning the double standard with slaughter. The dissents, not so comfortable. Barrett had a very short dissent, but she made the obvious point quite well. The court's holding is in serious tension with Trump v. Slaughter, which we also decide today. Slaughter announces a categorical rule. Whenever an agency executes a congressional mandate against private parties, it exercises executive power and must be subject to plenary executive control. No ifs, ands, or quasis about it. Yet here, The court claims a special exception, sanctioned by history, and based on the Federal Reserve's role in setting monetary policy. How can history support both a categorical rule and a carve-out? That's a great question.
It is a good question.
Thomas's dissent was much longer and much more angry, but he made a very similar point. I won't go into him because I'm looking at the clock. I should say, by the way, that Roberts not only didn't address the double standard, he literally never even mentioned the slaughter case in his judgment. Didn't mention it. That's pathetic. So what are your takeaways? What are your thoughts? No, you've already said it?
Yeah.
For the record, I'm with Amy Coney Barrett on this one. I'm in dissent. You have to follow Slaughter's new precedent. That's how, as a judge, that's what I do. I follow precedents. Let the country go to hell. Let's see how you enjoy your unitary executive doctrine then. My major takeaway is when they thought there were really serious consequences, Roberts and Kavanaugh folded. The dissenters, we don't know whether they're being crazy brave or super principled or just don't think it's a big risk. I should say the Liberals went with Roberts and Kavanaugh, but they're being consistent at least with the slaughter. We don't know what the dissenters are thinking. But what we do know is that Roberts and Kavanaugh apparently don't think there are really serious consequences coming from the slaughter case. Because we've seen how they react when there's really serious consequences. Maybe they're right. It's just a big unknown. But that is a huge risk that Roberts and Kavanaugh are taking with the country's well-being, a huge, arrogant, hubristic risk. And it becomes so much more hubristic when you compare it to what happened in Cook. So it makes me even angrier about slaughter.
Yes. For a theoretical conservative court, they're quite radical.
Yes. Yes, you're absolutely right. Okay, why don't you tell us of campaign finance?
All right. So in a 6-3 vote again.
Strong passing lines again?
Can I make a quick point about 6-3 votes?
Yeah.
Because Amy Coney Barrett defended the court back in 2022 against accusations of partisanship.
Yes.
And she said in the 2022 term, 47% of the cases were decided unanimously and only 5 of 58 decisions broke down by party of appointing president.
Yes.
Which is a little bit misleading because a lot of cases are technical and don't have an obvious partisan split. But let's focus on the 5 of 58 broke down by party of appointing president.
Yeah.
In this term, the number of cases decided along party lines of appointment was 13 of 56. Quite a bit more.
We're moving in that direction, aren't we?
So if you feel like the ideological slant of the court is ramping up, you're not wrong. There is evidence backing that up. So I just thought that was interesting context to add.
And after the abuse that Amy Coney Barrett copped from all of MAGA, even though I should add she wasn't the one who wrote the Birthright Citizenship ruling, it was John Roberts, and she copped the bullet anyway. There's going to be pressure for there to be more 6-3s.
Yeah.
Yeah. Yeah.
So campaign finance. In a 6-3 vote along ideological lines, the court struck down a law that puts limits on how much political parties can spend in coordination with their candidates.
Yes.
This is a law that had been previously upheld in 2001 on a 5-4 vote. Kavanaugh, writing for the majority, decided that coordinated expenditure limits violated the First Amendment. So this doesn't affect how much people can donate to a candidate or party. At the moment, you can donate $3,500 to a federal candidate and $44,300 to a national party committee. What they're trying to prevent is someone donating more to a party and saying, but actually give it to that person that I've already given $3,500 to and I want you to support. You're not allowed to do that. This law was designed to try and prevent that. And the ruling is saying that's unconstitutional because it limits the First Amendment.
Yeah.
The reason to have limits on campaign spending, we should just say, is to try and reduce the influence of money and limit the potential for corruption in politics. And this was the reasoning in the dissent, that removing limits on coordination would allow a donor in favor to give more money to the party, try and direct it to a particular candidate that they might have more influence over. Kavanaugh did note in his ruling that this hasn't proven to be a particular issue in state politics where they don't have this rule, and that the earmarking issue, it's already illegal, so you don't need this extra law preventing coordination. Parties and candidates should be able to work together. They have the same goal. They are all within the same unit.
Obviously, there's less money in state politics, though.
Sure.
Yes.
But also arguably more potential for corruption because there's less
true.
scrutiny.
Yeah, true.
and they still
Cool.
have the power to make a lot of laws.
Well done.
Thank you. Why are Democrats unhappy about this? Because it is the RNC that brought, or Republicans that brought the case in the first place. In the immediate term, it does advantage Republicans, which is presumably why they brought the suit. The Republicans have $125 million more than Democratic committees heading into the midterms.
Yes.
Now they can use that money more effectively, both by coordinating with their candidates and also because parties are legally entitled to lower rates for TV and radio advertising
Bingo.
than outside groups. So that money can now go further.
Sorry, let me just add one more thought to that. Democrats tend to have individual candidates raising more money
Yes.
from small donors, and the individual candidates are the ones who usually benefit from the discounts for ads.
Yes.
Because the candidates get discounts for ads from the TV stations. Now, with the party coordinating with the candidate, they can get the discounts as well. And so that allows the Republicans to take advantage of the fact they got more money in parties to get more discounts than they would have otherwise gotten because the candidates in the past are the only ones, and Democrats dominate amongst candidate funding.
Yes.
So, yes.
I'm personally, from a policy perspective at least, not particularly worked up about it.
Yeah.
I kind of feel like post Citizens United,
Yeah, it's
the election
busted.
spending
It's
cat
busted.
is well out of the bag.
Yes.
Campaign spending is just already so massive and unrestrained in any meaningful way that I don't know that this does make a big difference. Often the candidate with the most money doesn't win anyway,
Yep.
so it's not always decisive. And even more importantly, I'd say super PAC spending is so much higher than that of political parties. So in 2024, in that cycle, political parties spent around $2.6 billion to support federal candidates. $5.5 billion was spent by the candidates themselves. $15.5 billion was spent by PACs and super PACs. So, allowing political parties to coordinate more with candidates. The only argument for separating them is if you think that that's more likely to corrupt politicians than money through super PACs. And in theory, super PACs are not supposed to coordinate with candidates. But in practice, the idea that that's like a balm against corruption, I don't buy. So in that sense, I don't think it makes a huge difference.
Can I jump in with more super PAC stats while you're firing them out? In the 2016 campaign, there were no individuals spending at least $100 million in the campaign season. In the 2024 campaign, there were 9 individuals or couples doing so, all supporting Republican candidates, by the way. 1/5 of total federal campaign donations in 2024 came from billionaires and their immediate family members. And in the 2024 cycle, PACs raised $15.7 billion to $2.7 billion from parties. Yeah, so it's, the stats are interesting about super PACs.
Yeah.
They're the problem.
Yeah, and also candidates tend to rely on either these massive donators or small dollar donors. And, so I think in that sense, the system is sort of quite different to how it was when these laws were designed. I also tend to think if this decision incentivizes donors to give more money to parties over super PACs, that's not necessarily the worst thing politically. Like, political parties have, at least in theory, more transparency and accountability to voters than super PACs do.
That's Kavanaugh's argument.
Yeah.
He argued weakened political parties distort the political system, and in the views of many, the relatively diminished political parties have ushered in increased political polarization and fragmentation. For that reason, many who generally support campaign finance restrictions have called for elimination of the political party coordinated expenditure limits.
Yeah. And I think that's not an unreasonable argument.
It's true. He's right.
Yeah.
They have.
Yeah. He also said in his ruling that the court's decision today treats all political parties equally. And that's true. Just because it advantages Republicans this cycle, because they happen to have raised more through their parties than Democrats, people adjust to the circumstances on the ground. So, Democrats, I understand them hand-wringing in a sense, but it tends to be short-term thinking and also fundraising. A lot of Democrats being like, look at this ruling, it's so terrible, give us money. It's like, cool, that's them adjusting. And I would imagine if you're a cashed-up Democrat-leaning voter and you're looking where to put your money, you're more likely to give it to the Democratic Party now. So, I think just because the situation benefits Republicans right now, we shouldn't see it as a Republican ruling. This is something that it's a rule that does apply equally, and there's no structural reason why Democrats can't raise money through this mechanism as well. To be clear, I'm not saying it's like going to be a massive positive and we're in a new era of, money being non-corrupting in politics and only leading to good outcomes. But I think in a world where special interests can spend unlimited amounts on elections already, putting a bit more of that money into the light where we can see it through at least some better disclosure laws has at least some potential to be at least not worse than what we have right now.
Yeah, okay. Look, let me add some legal stuff and then I'll get back to the policy element. I think what a lot of people don't understand is the legal basis for this decision. I think it's actually pretty cut and dry. Like, I just agree with Kavanagh completely on the law here. We might have different incentives, but but I think he's right on the basic law, if we're ignoring reality for a second. In that the issue, let me give you the background, the history of this. Because after Watergate in 1974, Congress passed the Federal Election Campaign Act, which limited how much people contribute to candidates, parties, committees, limited spending, limited everything, right? And then that was immediately undermined by Buckley v. Vallejo in 1976, where the court held that contribution limits can be justified by the government's interest in preventing corruption and its appearance. And that became the key. Does it prevent corruption and its appearance? That's a legal question. If so, you can infringe on the First Amendment rights. If not, it's not worth infringing on First Amendment. That's the precedent that they're following, okay? But they said spending limits violate the First Amendment and they didn't prevent corruption, according to Buckley and Vallejo. Let me go through that logic, where they get that from, though, because it'll enlighten you to what I'm talking about here. They're arguing independent spending, like in super PACs, for instance, even though they didn't exist then, can't corrupt if it's not done in coordination with a campaign. Really? Who thinks that reflects reality? Part of the reason for that is because their definition of corruption, which a lot of people don't realise. They think of corruption as like, oh, oil companies donate, you help out the oil company, that's corruption, right? At least it's the appearance of corruption. No. I'll quote Kavanagh. In the more recent cases, the court has spoken clearly and definitively. Congress may not restrict spending because of the possibility that political parties, individuals, or outside groups that spend large sums may garner influence over or access to elected officials. Nor may they do so to limit the appearance of more influence or access. Speech regulations may not target general gratitude. The court has reasoned that ingratiation and access are not corruption, but instead embody a central feature of democracy, that constituents support candidates who share their beliefs and interests, and candidates who are elected can be expected to be responsive to those concerns. The court now recognises only one legitimate governmental interest for restricting campaign finances: preventing corruption or the appearance of corruption. Moreover, Congress may target only a specific type of corruption, quid pro quo corruption. And quid pro quo corruption, in turn, is something specific: contributions in exchange for official action. Anything other than that, a direct contribution in a direct exchange for official action from someone who is already a politician, is not corruption. Mm-hmm. That's the law as it stands.
It's another good example of what I was saying before, of protecting the rights of the powerful being the priority, because protecting the right of a billionaire to ingratiate himself with a politician is central to democracy, but protecting the power of everyday voter to have any kind of influence at all over policy making through their vote is not important.
Yeah, that's right. And so given that definition of corruption, let me ask you, stopping a Republican Party from coordinating with their own candidate, is that going to help reduce corruption? No, of course not. That doesn't have anything to do with quid pro quo, direct quid pro quos in exchange for official action. So that's going to have no impact on their definition of corruption at all, Kavanaugh's completely right. Under the doctrines they are following, this is not worth the infringement of the First Amendment.
Yes. I mean, having said that, I say I'm not particularly bothered by the outcome of this in the sense of it seems like not that bad relative to some of the other changes, and in the context of the way election finance works now, I don't think it's going to have a big negative effect. But I would push back a little bit against just kind of running along with, the court sets a terrible standard, so then we look at any subsequent ruling as being like, well, that's consistent with that standard, so that's very reasonable.
Oh, yeah.
Because the standard that was set in the first place, I think, is a terrible standard.
Yes.
And so, it doesn't, even if it's like, yes, that's the correct ruling, if we are interpreting this bad standard you've set, so well done. It's sort of like, well, yeah, but that standard is not good and we shouldn't just accept it as normal.
Oh, I 100% agree, which is why I feel that Buckley versus Vallejo is the number one ruling that needs to be overruled. People go about Citizens United all the time. No, Citizens United is not the problem. I mean, Citizens United made things a lot worse, but the original sin is Buckley v. Vallejo. That needs to be overturned. The definition of corruption needs to be overturned, and the whole logic of Buckley versus Vallejo needs to be overturned. And that, in my view, should be the left's litmus test. That's the only way you're going to get actual campaign finance reform. So that's what I think the left should be focused on.
I reckon if you asked an average person in the street, would you consider it corruption or the appearance of corruption for a billionaire to spend heaps of money in a political campaign with the explicit intent of gaining access and influence over a politician? Most people would say that, yes.
Of course they would.
It's just obvious.
Of course they would. The Supreme Court's been systematically undermining corruption laws for decades. They need to do some serious overruling in this area. And I'm just saying that's where it starts. Buckley versus Vallejo is where it starts. Because, yes, everything that's flowed since then has just gotten worse and worse. And yes, Citizens United made it so much worse, because those who don't know what Citizens United actually is, that's from 2010. Yeah, that was where the Supreme Court struck down limits on independent spending by corporations and unions. They said large independent spending, even from corporations, can't corrupt if it isn't in consultation with the candidates. And of course it can't. Of course it can't corrupt. Their definition of corrupt is a direct quid pro quo in return for some kind of favour. If you don't coordinate with a candidate, they don't know exactly the exact favour you want, and you can't get an exact price, and you can't negotiate the exact bribe, and that's the kind of stuff they're looking for with their stupid definitions of corruption. So it's all legally makes sense, but it all flows from the same bullshit, which should be overturned. That's what I'm saying.
Yeah.
So and that's what let the super PACs go. As soon as you let independent expenditures go through the roof, it went crazy. And now you have this perverse situation where you have literally Brett Kavanaugh citing super PACs as the reason to have further deregulation of campaign finance. Literally, his argument was that super PACs are unaccountable, whereas parties help preserve democracy. And so we need to help encourage people to donate to parties by deregulating the financial restrictions on parties, because they're better than super PACs, which they are. They actually are. but we've gotten to this screwed up situation with their dumb rules. I mean, Eleanor Kagan just got right into that. First of all, she wrote, "The majority laments that political parties' relative power has substantially diminished in comparison to super PACs and other outside groups that can receive and spend unlimited money on political campaigns. But surely that one is rich. If one is overruling or just reversing decisions on that ground, I can think of a couple of more obvious ones. That is, the ones that created the modern super PAC system and thus the complained of imbalance." And then she cited Citizens United. And then she also said, "The majority's new equilibrium theory. Overrule Colorado 2, that's the campaign finance law one case. The overall Colorado 2 to restore the party's proper role in American politics is shall we say, seat of the pants. I suspect it will not be difficult in a decade or two to disprove the majority's view that what has been standing in the way of a fully functional party system is Colorado too. She's very droll.
I'm going to say, I do like Kagan. Biting.
Yeah, I like Kagan too. Kagan and Barry are my two faves. And then Kagan went on to just go through in detail exactly how the actual corruption works, as opposed to the bullshit corruption that they use legally, or that they use legal terms about. I won't read it because it's just, you know how corruption works. it's just you donate to the victory, to the what they call it, the victory fund, which is $550,000 worth, and then the party distributes it over all the limits. Because that's the other thing. This doesn't change any limits. It changes the coordination numbers, but not the actual contribution limits and the spending limits. But of course, you can work around them. Once a party has $550,000 and can coordinate with you, you just don't say you're directly coordinating. You don't say it's going to that person, and it's violating the earmarked individual campaign limits. Anyway, I'm not going to waste your time on that. You get the idea. Anything else you want to add on that one?
No.
No? Okay. Okay, one more quickie. Mail-in votes, Watson v. RNC. Background, 18 states and territories currently allow for mail-in ballots to be received after Election Day. Those include Mississippi. In Mississippi's case, they allow a grace period of 5 days as long as the ballot is postmarked as being mailed before or on Election Day. This case is about whether Mississippi's law contradicts federal law. Incredibly straightforward. Let's get straight to the majority. There's a 5-4 decision with the Liberals and Barrett and Roberts. It's another reason why they hate Barrett, and they don't like Roberts very much either. Barrett wrote the decision, and this is what it says. She said, the Constitution's Elections Clause empowers state legislatures to prescribe the times, places, and manner of holding congressional elections. Congress may override most of these choices. By default, however, responsibility for the mechanics of congressional elections belongs to states. As Alexander Hamilton put it, the Constitution lodges power over congressional elections in state legislatures primarily and in Congress ultimately. So she said it's not a case about the Constitution. It's solely a question about whether counting ballots postmarked by Election Day but received up to 5 days later violates the federal Election Day statutes. Everyone agrees with that, including the dissent, which is written by Alito. So let's turn to the federal Election Day statutes. What do they say? Barrett says, the statute governing presidential elections provides that presidential electors shall be appointed in each state on Election Day in accordance with the laws of the state enacted prior to Election Day. And there's similar laws for House elections. The statute governing House elections establishes the day for the election of representatives as the same Tuesday in November in every even-numbered year, etc. And the calendar for Senate elections follows suit. Senators are elected at the regular election, at which election a representative of Congress is regularly by law. Okay, so essentially they say Election Day. That's what the statutes say. There is an Election Day. What does Election Day refer to? Barrett says, although the Election Day statutes refer to a particular day for the election, plaintiffs do not contend that everything must occur on that day. For instance, they do not object to early voting or dispute that officials may count votes and certify a winner after Election Day. All right, so what does it refer to? Barrett says, by setting the day for the election, these statutes set the day when the electorate must make its choice. She cited a number of precedents for that definition, including a case called Foster. In Foster, we explain that when the federal statutes speak of the election of a senator or representative, they plainly refer to the combined actions of voters and officials meant to make a final selection of an office holder. The main point was the electorate's choice is made when voting is complete, not when ballots are received. Alito wrote the dissent. His view was that the electorate's choice should be defined as the final submission and collection of ballots. So he adds collection of ballots to what has to happen. He wrote, Back when all voting occurred in person, the voters went to the polls on election day. They then completed ballots and turned them over to election officials. When the polls closed, those officials had in their possession a fixed collection of ballots, and taken together, those ballots embodied the electorate's collective choice. The expression of the electorate's choice having been made, the election day statutes did not require that anything more be done before midnight on election day. Of course, no one could know the outcome of the election until those ballots were examined and the valid ballots were counted, but it was not necessary for those steps to be finished on election day because the electorate's choices had been authoritatively expressed. Now, obviously not all voting happens in person. So how does he account for that? He says both voting by mail and early voting have become popular, and respondents do not dispute the lawfulness of these modern practices, nor do I. But the acceptance of these practices cannot change the fact that under federal law, the electorate's collective choice must still be authoritatively expressed on election day. That requirement is met in a jurisdiction with mail voting or early voting, provided that the critical act occurs on election day, the completion of the collection of the ballots that embody the electorate's collective choice. That's what took place when all voting was done in person, and compliance to the election day statutes demands the same occur in a modern election. The court disagrees and concludes the election day statutes merely require that each individual cast a vote on or before election day. But if that's all the election day statutes require, there's no sense in which the electorate as a whole could be seen as making its choice on election day. Rather, the electorate's choice would be made piecemeal over an extended period prior to election day, and that prospect is blatantly contrary to what the election day statutes demand. We have two competing definitions there, Melina, for what the electorate's choice is. Before I go any further, do you have any thoughts?
Well, if you're going to be really strict about voting having to happen on election day, that's more easily achieved by doing a mail-in vote that's received several days later than it is by doing an early vote, which is not done on election day. So I don't really understand his argument that early voting is okay, but mail voting isn't.
He's saying that the final vote needs to be collected by election day. He's saying things can happen before, but on election day, you need to complete the process. I've got a quote from him coming up, but I won't read it now. I'll read a bit of it. To reiterate, it's the electorate's decision, not the voters, that constitutes the election. And no matter when a state receives voters' individual ballots, the electorate's choice is not made until all ballots have been cast and collected. So long as that occurs on the Tuesday after the first Monday in November, the election day statute is satisfied.
Yeah, but he's putting the emphasis on the collection rather than the voting.
Both have to be completed by election day, he says.
But I'm saying I don't agree with the collection part. The voting part seems like the key part to me.
Well, and you agree with Barrett.
I do.
Yes.
You may as well read her argument because she's going to put it better than me, but I know her argument and I agree with it.
So now we go to see if there's any court precedent or other legislation that can help us pick the most appropriate definition out of the two. Alito has nothing. He cited one case which was kind of garbage. Barrett, to be honest, didn't have a huge amount, but she did have something. In 2022, Congress inserted the phrase election day into the election statute and marked that day as a specific Tuesday. It then created an exception. When states modify the period of voting in response to certain force majeure events, the term election day shall include the modified period of voting. That Congress defined election day with reference to voting indicates that voting is the act governed by the statute. That was a pretty good point. She also noted that the UOCAVA, the Uniformed and Overseas Citizens Absentee Voting Act, requires states to permit absent military and overseas voters to cast absentee ballots in federal elections. As a backup, it establishes a federal absentee voting system. In detailing this system, it repeatedly presupposes that ballot receipt is a matter of state law. For example, it specifies that a federal absentee ballot shall not be valid if the state provides an absentee ballot at least 60 days before the deadline for receipt of the state ballot under state law. It also mandates the ballot of overseas military voters be delivered to the appropriate election officials not later than the date by which an absentee ballot must be received in order to be counted in the election. Finally, to avoid any double counting, it provides that federal absentee ballots shall not be counted if a state receives a voter's state absentee ballot by the deadline for the receipt of that ballot under state law. If election day statutes establish a nationwide ballot receipt deadline, these references to state ballot receipt deadlines would make very little sense. which I think is also an excellent point. And then we turn to historical practice. Both sides claimed history on their side. Alito, because for the first 150 years or so, there wasn't much mail-in voting. Barrett notes during the Civil War, 2 states tasked military officers who were not deputized as election officials with collecting soldiers' ballots on election day and then sending the ballots to state election officials for counting, which meant the ballots were not received into official custody until after election day. And then she also added during the 1940s, 7 other states authorised the receipt of ballots after election day, reflecting the belief they were free to do so. Plaintiffs offer no evidence that any of these laws were ever challenged under the election day statutes. Alito acknowledged all of those exceptions, but just waved them away because the bulk of voting through America's history was in person. Fine. And the final point made by Barrett, which was, I think, a decent point, was that there's no doubt who's in charge of election law here. It's the state. So if Congress doesn't clearly express its preferences, the state gets to do what it wants because it's the state's power. Nowhere in history has Congress explicitly said the electorate's choice involves ballot receipt. Never. And so courts shouldn't impose that interpretation on states. Barrett wrote, "The framers recognised the difficulty of crafting election laws applicable to every probable change in the situation of the country. So instead of constitutionalising election law, they decided that the discretionary power over elections need to be lodged somewhere. Suffice it to say, that power was not lodged in this court. The election day statutes say nothing about ballot receipt, and we cannot add to the words Congress chose." A bit of humility there.
I was about to say, finally some humility. Yes.
Was there another argument from her that you liked? You said you liked one of her arguments.
No, that was
the one?
It was all the things you just said.
Yeah.
But also, we just note, like the election finance case, there's no reason why this should be an inherently partisan issue. And in fact, active duty military, which tends to skew conservative, is one of the key voting groups that risks disenfranchisement if you make mail-in voting overly restrictive. So, I don't really, it feels very short-sighted to try and gain some marginal partisan advantage out of restricting it through a, hard to support constitutional argument when in reality you could just encourage your voters to vote however they want to.
You could. You could. And and this isn't, it's really easy to solve this. This is just, once again, just Congress. You can just change the law if you want to make it clear. No, I don't think anyone really, I don't care, to be honest. This is not a policy issue I care about. I'm happy for mail-in voting to end 3 days early so that all the votes get there by the day, if they had that. And that's what would happen. If this was the law, that's what would happen.
I do think the most fair version is to have a grace period, because if you say that you have to do a mail-in vote early, some people, mail-in voting is the only realistic way they can cast a vote for various reasons. They might live in a very rural area, they might have disability, all kinds of issues. They might not be able to vote on the day because they have to work. I think for the vanishingly small part of the population that still swings in their vote, they might like to wait until they've seen the entirety of the election campaign before making their choice. And I feel like insisting that you have your vote received by a certain date, you also can't guarantee how long it's going to take. So you're forcing people to vote quite a bit before the end of a campaign. And I think it's unfair to say, you should have less. You are not allowed to have the same information as a voter who is able to vote in person. To me, it's a good law to say, not an unreasonable one, but, with this law is 5 days. That's totally reasonable. If you're really late and taking the piss, then that's on you. If you want to guarantee your vote definitely makes it in time and you know who you're going to vote for, vote even earlier. But I just think a grace period, just completely non-partisan reasons, just makes sense and is very fair and is not obviously, a huge risk for abuse or anything. It's just good policy.
I agree. If I was writing the law, I would have that law for this exactly the same reason. I'm just saying, it's not something I care a lot about.
Yeah, sure.
I don't think it's a big deal. But you say there's no risk of abuse or whatever, but Alito, he had a lot to say about that. He asked a bunch of questions. Could a state therefore count late arriving ballots if they're delivered by some other intermediary? How about a relative of the voter, a helpful neighbour, an Uber driver who agrees to serve as a courier, a ballot harvester affiliated with a political party or interest group. That seemed to me to be an incredibly stupid line of argument. Barrett dealt with it in one sentence. Plaintiffs and the dissent argue that if we uphold Mississippi's law, states could put party bosses, ballot harvesters, or Uber drivers in charge of collecting ballots. Yet this would also be permissible under their interpretation, so long as the ballots are delivered by Election Day. That kind of nails it. I'd also add, of course, those things can happen, of course, if the law allows it. If you don't want those things to happen, then pass a law stopping them. That's how democracies work, Sam. And then he finally finished off with this lurid hypothetical. I won't read it out because it'll take forever and you got to go in a second. He focused on a situation where on the fifth day the results changed and everyone lost all faith in the election. And they had just essentially just painting a situation where people fear that the vote is rigged because it changes after the day and the votes haven't arrived yet. Right. Fine. They're policy arguments, not legal arguments. Change the law if you want to change the law. You know what I mean? Like you can't just wish that law into existence, Sam. You need to pass it with Congress. And if Congress don't pass that law, you can't just pretend they did, which is what he's been doing in this case. Yeah. So anyway, that's my thought on that. Do you have any other thoughts on this case?
No.
Oh, by the way, Trump's reaction was to pass a SAVE Act. And I go, yeah, what? I'm okay with that. He's right. Pass the SAVE Act. I mean, I don't like the SAVE Act, but I'm saying if you want to change that, pass the SAVE Act, then fine. That's kind of what you do. You get Congress to change the law if you disagree with it. But my main takeaway is this. I thought this case here, I have no idea how Alito, Gorsuch, Thomas, and Kavanaugh, how they possibly could have voted in the dissent on this. It's the most obvious case. I think this is the most obvious case out of the 9. There is just nothing justifying their take other than it's what Trump wants. It's just, there's no law behind this at all. There's no history. There's no text. There's no tradition. There's no anything. It's just wishful thinking. And I'm astonished that they would allow themselves to look that hackish just to fall in line with Trump's desires. I know, sweet summer Chaz. I found that so embarrassing. This case and the Birthright Citizenship case combined tell me that this court is one justice away from becoming completely useless. Like, honestly, I found it scary that they'd support something like this. And I still wouldn't support packing the court even now because the court is still functional. And as soon as you pack the court, the whole thing's over, right? So, like, while it's functional, I'd cling on to it in the hope that it stays functional. But if any of the 5 justices in this majority here, the 3 Liberals plus Roberts or Barrett, are replaced with a hack, man, I think the court's gone. I don't know what your take is on that. You got any thoughts?
Yeah, I tend to agree.
Yeah. It's just, like, honestly, thank God that Trump appointed Barrett rather than the kind of person he actually would want to appoint. That is such an accident. There's no way he wanted to appoint her.
Of course not.
That's right. So it's just like we should, if you want to be grateful, that's something we should be grateful for. Whether you like Barrett or not, at least you can admit that she is sane. It's just... And that she had, like, it's just, I mean, and I disagree with, I mean, there's all kinds of rulings she does that I disagree with, but she's not the end of the court.
She's not a hack.
Yeah. Well, not a full hack at the very least. Yeah.
Sometimes she's not a hack.
She has her moments, but I'm not giving up on her like I'm giving up on people who support this crap. Anyway, Melina, thank you so much.
Thank you.
For seeing through 9 lengthy cases. And for all the time you spent looking through all those. It's like 500 pages. It's a lot. Do you have anything to add?
Happy birthday, America.
Yeah. and I'm going to celebrate America's birthday by going to sleep.
Yay.
For another, see you guys in about a month's time. Subscribe if you want to know when we come back and you don't miss anything. And in the meantime, have a great month and stay peppy, and I hope America's still there when we come back.
Me too.
I'll see you in a month. Stay peppy.